my lords had passed that first order regarding these army officer and army officer's fiancé. That matter probably will come before my lord. May I pray, my lord, for next week, because the urgency is that poor boy, that captain, will lose his job otherwise, my lord. He'll not be promoted also. If the state comes up that what is their
Why he lose the job within a week?
my lord.
I'll list all the matters serially so that it will come up.
I quite understand that. But the only urgency is that, my lord. My lord, if the
You tell your instructing counsel to give the memo. Let me see.
Yeah, I'll be deeply obliged.
I'll just show you that file. If it's very urgent, overnight urgent is there, then only otherwise serial it will come.
Yes, my lord. I quite.
But I don't want to jump the queue.
No, my lord. Because not because of the queue, my lord. My lord, because of the urgency of the matter. Otherwise also it will come within 10-15 days. I will design the list in such a manner that all the matters can be heard. I'll be before my lords the entire of next week. So, if it's possible, my lord. That is. Let us see. Let us see how things move. Deeply. Okay. Yes, Mr. Mishra.
Item 51. Item 51. I pray, my lord, I have informed Mr. Senior Counsel, Mr. Panigrahi. You lordship may call this matter 2 weeks after. 51.
Yes. So this is any stage operating? No.
It's a fresh matter, and Mr. Panigrahi, you wait to file the counter.
This case number 4117/14 for further regarding stay.
Who is appearing? Who is appearing for the other side?
Item 51 appearing Mr. Sagar Panigrahi.
Your Lordship, item 51 on behalf of Mr. N.C. Panigrahi.
Yes.
And in the meantime, he may direct you to file the response because he is supposed to file the response.
They may file, they may not file. We don't know. Let us see. Yes.
Modification of the order. Modification of the order. Order dated 10
DC.
There was 2024. Many memos have been filed, but not listed. Quashing of FIR.
Fresh matter. It will come in serial. Don't worry. Give it. It will come. Don't worry about it.
Beg to pardon, my lordship mention item 101. Item 101 list. Kindly adjourn 1 week after.
You are holding brief in your hand or what? What have you written in your hand?
No.
The number?
Number.
Okay.
Item 101.
I don't have the entire case is in your hand. Anyway. 100?
101.
101. You want an adjournment?
1 week after, lordship.
Appeal, my lord.
Appeal, let it be there. After 1 week, I'll take. Don't worry. Yes. Yes, sir. 97? Yes. Special urgent matter. Who is from the other side?
Well, and
All matters will come. Don't worry.
another is the appeal of conviction against business.
First matter? First matter?
No, initial.
That will come. Don't worry.
It was in the list, but
That will come. Don't worry. Give it to kick off. Yes.
Yep.
That's
33.
34.
34.
Yes.
34 and 36, my lord. 34 and 36, my lord.
What is this?
It's the same, my lord.
36 lords arising out of one FIR, 2 different sessions trial numbers. Lords, challenge is
Because there are two accused.
yes, different accused persons.
Yes.
One after another.
You are challenging a 9/1/2024 order.
24 order. Lords,
Yes.
on the ground that the police has not filed the final charge sheet and the investigation has been kept open. Therefore, the framing of charge may be deferred. That was my petition, which has been rejected.
All the
23 is the order.
Absolutely.
Financial subject. So far, the last may not record my concession. From the beginning, 34, 36, arising out of same FIR.
What do you want? Why don't you withdraw? That's a better thing. Why you are inviting?
That will create a problem for this.
I'll dismiss, then I'll have to say something. It may,
With liberty to raise the point.
yes, that's a better thing. 34 and 6. The matter was heard at length. Matter was heard at length. And Mr. Ragada opposed the prayer made by the petitioner. At this stage, and learned Mr. Pradhan and counsel for the petitioner submits that he would reserve his right to raise all the points which has been raised in this petition at the appropriate stage before the trial court. And accordingly, he seeks withdrawal of this petition so as to enable him to raise all the points before the court below at appropriate stage. With this liberty, the petition is disposed of.
We very clear from the beginning. Is that
I know this is the fairest thing one can do. Thank you very much. 34 and 35. Thank you, sir.
35.
My lord, this is a case arising out of complaint case, my lord. It is a headmaster, my lord, of a government high school, my lord. My lord, allegation is that in a one particular case, my lord, the petitioner filed the forged and unoperative document. My lord, kindly see.
You are seeking what? Quashing of or the FIR? Okay.
My lord, yes. My lord, the kindly see annexer page 37, my lord. On where I am not the petitioner in the criminal miscase. My brother is the petitioner in the criminal miscase.
Yes.
But in the 1cc case, the complainant alleged that the petitioner made forged and fabricated document in a proceeding in criminal miscase number 523 of 2020.
Show me the complaint.
My lord, that is 37. That is
understand, madam, first paragraph, my lord, of his petition, my lord. But PS case of 2023, how did my lord, GR case 22, my lord? That is, my lord, in all pages, he has mentioned that PS case number 23. GR case to 22 size. Somebody after petition, entire petition.
Entire petition you have written like this.
sir, actually. PS
Be sure about what you are writing. Everywhere you have written. Some orders are part of the new application.
typographical error.
Typography notice na jaga hai wo sabudi.
Court and
Your case, I don't think you have a
petition.
Really, but it is not 340. Well, it's not a 340 petition. It is the cognizance is taken for the offences under section 209, 465 and all.
My lord, in the जो 144 केस जो फाइल होची मु सेतरे पेटिशनर न से कहउछन जे 144 पेटिशनर मु फॉर्ज एंड फैब्रिकेट
Show me the complaint.
my lord, that is annexure 3, my lord.
Annexure 3 complaint.
Sorry, the page 37 144 proceeding, my lord. Se would get प्रथम
That I understood. Now you show me the complaint in which the cognizance has been.
my lord, that is annexure 1, my lord.
Annexure
1, my lord.
FIR. Yes.
Cognizance, they are not challenging cognizance, my lord.
FIR, sorry, FIR. FIR, what are the allegations?
My lord, the description, my lord, that the petitioner document that the complainant is a lawful
Statement, report, and affidavit which
That amount-
the cause in the document so. And what is the stage of investigation?
My lord, investigation going on. Perhaps he has not cooperated the investigation, my lord.
You go and cooperate or tell all the thing. I want. I'll give that liberty. I'll give that liberty. What is happening is, what he says, see, come to page 10.
My lord.
That is his case.
My lord.
Page 10, date and time and place of occurrence.
Right.
Let's read C. On 18/9/2020, when the accused filed so and so case. Yeah, he has not filed.
No, I have filed against.
He will not file. Some other person will file.
That he is correct, my lord. For that, the man for 68, 65 offense was he.
So therefore, he is to go to
Judgment, my lord.
So that my his brother has done it, not he. That's what he says.
But that is one of the 34 is there, section 34 there, my lord.
So therefore, I will do that. I will do that. The petitioner is seeking quashing of the FIR number so and so, corresponding to your case number, my lord, 1111 of 2023. Okay.
No, 22 was it.
22.
My FIR is wrong or this is wrong?
FIR wrong.
FIR wrong.
22
Okay, 22 kar 331 of 2022.
True.
Corresponding to FIR, GR case number 1111 of 2022 for Ellie's commission of offense under section so and so. The learned counsel, Mr. Patnaik and counsel for the petitioner submits that the basis of the FIR is that the complainant in the FIR has alleged that he had filed a miscase number 543 of 2020 before the executive magistrate Khurda and has given false statement in the state proceeding and also relied upon manipulated documents. Therefore, he has manipulated document. Learned counsel for the petitioner submits that in fact it is his brother who has filed the miscase number 543 of 2020 before the executive magistrate Khurda. In that view of the matter, he says that the entire basis of the FIR registered against him is on the false premises. Hence, he seeks indulgence of this court for quashing of the FIR. Mr. Ragada, learned counsel for the state, submits that the FIR is at nascent stage of investigation and Therefore, indulgence of this court at this stage may not be called for. Rather, the grievances raised by the petitioner can be apprised to the investigating officer who shall deal with the same in accordance with the law. In that view of the matter, I am not inclined to entertain this petition. However, liberty is granted to the petitioner to point out these aspects of the matter to the investigating officer who shall deal with the same in accordance with the law. With this observation, the petition is disposed.
I want to know whether investigation is pending.
I am pending as.
Yes.
Correction
Correction
37. One line, minute. If investigation continuing, madam. That may be mentioned. Everything, madam.
If investigation continue. Yes.
37.
Yes. Who is appealing? 37. Let's see what is this matter. Cognizance order. 21 cognizance order.
Madam.
Anything survives?
It's in high.
May not be surviving, therefore he is not teaching. Nobody says.
Exactly.
I'll just pass it over. Let us see. Pass over. Yes.
38. Item 38.
Yes, sir.
Order at page 102.
102. Okay.
And after the 202 inquiry, he has dismissed the petition.
102. 202. Huh?
No, page.
Page
Number page 102.
This is item 13.
38.
38. But I think the total number of pages are 99.
No, this is standing.
That's there.
Standing.
You are which annexure you are talking about?
Yes, sir.
7. 95 to 99.
97 to 103.
But here at 95. Anyway, let us see.
Certificate is here.
Maybe let us see.
Certificate was very private.
94 to
96. Answer 6. But this is there.
Okay, let us see. Yes. 94, that's what it is.
But
Correct.
the order dated
And 95 is your annexure 7.
Answer 7 is 97, starts from 97.
No, you have some problem in page initial. Here 95 here. Anyway, I can look at.
Order dated 11/10.
Eh?
What plus last?
Sorry.
Order dated 11/10/2023.
Okay.
What's last?
What's last?
I filed the inter order
11/10?
2023.
11/10/23. Yes. Please read.
The case result were put up today for orders in the matter of cognizance to establish the enrollment of each and every accused person in the commission of the alleged offences. The complainant must prove the role of each of the accused persons. There are 19 numbers of persons shown as accused. But in this case, including accused number 2, who was did an IAC of Kuchinda case. But in this case, the complainant did not prove the role of each accused persons. Further, the complainant has to prove that the accused number 2 has committed the alleged offence while performing of his duty, which is not established by the complainant. The complainant further alleges that he has kept metals and chips which are taken away by the accused persons, but to establish that he is the owner of the metal and chips, no document were furnished in this regard. Furthermore, on perusal of the inquiry under section 202 of witness 2, it is found that the complainant suffered injury on his head and sustained financial loss, but no such injury report in support of the complainant has been filed in this regard to establish this case. Again, on perusal of the final form submitted by the IAC Kuchinda, where so and so is found, complainant Manoj Kumar Naik lodged an FIR against the accused person Srikant Kumar so and so on the same point of issue. Separate charge sheet has been filed by Kuchinda so and so. Despite of the above facts, complainant has filed this complaint in case in the same fact. Considering the above facts and circumstances, this course is considered view that there is no sufficient ground to proceed against the accused persons as alleged under so and so.
How many accused persons?
20 items. 20.
Malakai.
And the GR case, my lord, there are
My trying to see page 90. I have annexed the evidence of those persons, and they have stated. I'm reading that.
And all the evidence you could not substantiate in the inquiry.
Kind of what they have stated.
Yes.
I have annexed those evidences for
Yes.
accused during the time of 202 inquiry. Mal kind come to
Which witness?
95.
Sushil Kumar Naik. Yes, 94. Yes.
This is Jagdish Naik.
Jagdish Naik.
I know the complainant would
1 minute, Jagdish Naik.
Mal.
Jagdish Naik is witness number?
Witness number 1.
Is
The answer 6.
95.
annexure 6, you have filed only one witness, that is Sajal Kumar Naik. Complainant.
So Sujal Kumar Naik.
Sujal Kumar Naik. That's all.
I also did read that.
Hmm.
I know the complainant of this case. I know the accused persons of this case. This incident occurred on so and so at about 10 a.m. in front of the Joint Temple. On the said day, the complainant gathered sand, chips, and metals over the land for construction of a house. The accused persons took away the said materials. So there was a quarrel between the complainant and the accused persons. After the said occurrence, I reached at the spot on the spot. On 10/5/2019, the accused entity so and so told me to say the complainant about the threatening given by him. The complainant suffered injury on his head and sustained financial loss.
See, there are two aspects here. One is the chips and material and all. You have not shown your ownership. Second is you say that you got suffered injury. You have not filed anything. So that's what the court says that one is that.
But this is not right. These are at the threshold. I have stated so. And
Amar says the court has to be satisfied with two-line statement. On that basis, even someone, so many people.
all the persons came and attacked me and took away everything.
I have to see whether my name is there or not as an accused. I have to see whether my name is there or not. You never know. See, why don't you understand? 19 people who want to prosecute, you say nothing of anything to anyone.
Well, I know when I objected.
Only services should say, this man has done this or that man has done it. Show me the complaint at least. Let us see if the complaint is something made up.
Complaint is that
5 series.
Where is the complaint?
5 series. Page
85 to 93.
Just come to the complaint.
Yes, sir. Yes, sir.
Okay.
Yes, sir.
Date, time and place of occurrence. What did you say? Nothing.
Yes, sir. I can come to page 86.
You are holding a very bad brief.
It's 4 minutes of
I understand, but what
only the notice is opposite.
but you can't improve your case. I would have issued notice if had it been 1 accused or 2 accused. 19 people, you know. 19 people serving them, bringing them here, and there is, you show me 1 allegation against any one of them. Violation notice. Confining to that accused.
And the complaint is I stated so.
Show me.
But other kind can come to page 86.
Yes.
All have named and
Only the names are written. You have not said anything against anyone.
not the facts of the case.
So read it.
They are on the date and time of occurrence, all the accused persons abused the complainant in obscene language, assaulted brutally, removed the metal and chips worth of so and so, and threw away machines, placed the neck of the complainant in order to murder. The accused number 2, the ISC Pochenda PS, was present at the spot, who has instigated, encouraged other accused persons to do the aforesaid misdeeds. So also all the accused persons threatened the complainant to kill him life in future. But that the complainant is highly terrified and apprehensive danger to his life. The witnesses intervened and
No, sir, you have not made anything.
but they have stated so. What I have stated, sir.
And you are making allegation against the police officer. There is
That is only he had dismissed it.
sure. No, that, rightly so. Because see, if the police officers are not protected, tomorrow he will be building his entire career is known.
Not Suresh Amit. I am not pressing against the accused person, the police officer. Then notice the against
You are not said anything against. See, idea of a complaint, I will not tell you. Idea of a complaint case is you have made a general allegation. All the issues have done this against me. Okay. And therefore the inquiry takes place under 202. In 202, explain which sections have done what. Then only information will be taken. In 202, it is so the allegations are nothing. And in 202, you have said nothing.
But the evidence is summarized, sir. I did not trial. During the trial, I will say everything in detail.
I think you.
I'm not pressing against the police person.
No. Rather, police person, you said something against police person. And the other accused person, nothing. You have a very bad case.
No, only notice.
No. Let it. Hard case. I'll just pass an order. I'll pass it.
Dispose.
Dispose. It's very hard case. Yes.
39.
And if you 39, yes. I can't keep anything else. Not what you.
University can give me everything. But
Today is giving something on record.
today my may not be able to give me something. But tomorrow I will take.
Oh, yes, that's right. That's right. That's a good spirit. That's a good.
Similar spirit. Who are the contractor tender pipe of
Yeah. He says that in a better case, I will impress. Yes.
ଘଟଣା ଫଟୋ ଦୁଇଟା କମ୍ପ୍ରମାଇଜ ହେଇଯାଇଛି କମ୍ପ୍ରମାଇଜ ଆଉ ଆମର ହଜବେଣ୍ଡ ସେ 5ଟା କେସ୍ ଫାଇଲ କରିଥିଲା
Bring them.
हम ଆଣିବୁ ସେଇଟା ଆଉ ଦୁଇଟା କେସ୍ ର 29 ତାରିଖ ଅଛି ଡେଟ୍
This matter along with so on 29.
ଚ୍ୟାଲେଞ୍ଜ 31 and 32 up to
31 and
32 up to 124
okay, number, CRLMC number. Okay. Finish on 29. Huh? And bring them on that day.
Aye.
All the matters will finish. Okay.
41.
May I please, Your Lordship? I am excused, I am in busy matter.
Yes, sir.
My lord. In this matter, compromise has already been done, my lord. And the
You are
allegation
depriving us to see you in person. What to do?
tomorrow onwards, I will be available. Today, I am outside station, my lord.
Okay. It's all right. Yes.
My lord.
Yes.
Well, this matter has been compromised. It is allegation against 376(2)(n). Your lordship, if your lordship will see the FIR, no 373(2)(n) is not made out on the FIR also. And now the it has been settled between the parties.
there is no any documents
available.
No, do you have you filed anything to show that you have settled? Or
No,
anything else?
she will appear also in this court. She will appear.
Notice.
No, no.
I am made the informant as a party also.
Okay, then I just then I just I'll say that you have settled the dispute. Therefore, I'm issuing notice. Okay.
Otherwise also it is not maintainable. My lord.
No, don't say otherwise. Otherwise, maybe may not be possible.
Both the angle I have.
Mr. A.K.
Yes, dear Lord,
Vishwal,
on next
counsel for
week
the-
they will.
Yes. Mr. A.K. Vishwal and counsel for the petitioner submits that the accused petitioner has entered into a settlement with the opposite party number 2, the informant in the present case. Hence, he seeks indulgence of this court for quashing of the entire criminal proceeding against the petitioner. Issue notice to the opposite party number 2, written will next week, next week Monday. Yes.
Yes, sir. Obliged. Obliged.
And file affidavit. And Mr. Vishwal therefore submits that he would be filing appropriate documents to substantiate his claim of settlement. Issue notice to so. Okay. Yes.
42, let's say item 42, praying for an adjournment.
Why? You argue.
Government senior will argue.
Is there anything material is there? Against what?
20B, 2C, 29 NBPS, my lord.
NDPS question.
My lord, and petitioner is the owner of the vehicle, my lord.
You raise all the point before the court below.
One adjournment.
No adjournment.
Kindly pass over.
Now, password, yes. Password, yes. Yes.
44.
May I please, Your Lordship? I am appearing to virtual mode, Your Lordship. In the
Yes,
present.
madam.
Lordship,
Yes.
Item 44, Your Lordship.
Yes, yes. Tell me.
I am appearing through virtual mode. Your Lordship, in the present case, against the rejection of the discharge petition, the petition has been implicated under section 376 and other offences, Your Lordship, on the ground of consensual relationship between the parties.
That consensual relation or no, that will be tested in the trial only. You have to, how can you will discharge? You proving that it is a consent, it has to be proved by the court that there is a consent.
373.
And for that, immediately case of 376. So therefore, you have to put appropriate question to the prosecutors and all, then you prove that fact, is it? Question of fact.
Yes, Your Lordship.
Will you raise all these points before the trial court? I'll give it later. Then counsel for the petitioner seeks to withdraw this petition, reserving her right to raise all the points before the court below during trial, in the appropriate stage during the trial. Hence, he seeks to withdraw this petition. The petition is disposed of as withdrawn with the liberty to the petitioner to raise all the points before the court below at the appropriate stage for the trial.
Obliged, Your Lordship.
The duration petition is disposed of. Yes.
45.
You have to look it over. 44. 44. First, first paragraph. The petitioner is receiving the order dated so and so passed by so and so, whereby the application under section 227 of CRPC seeking discharge had been rejected. The ground of challenge and the present petition is that there was a consensual sexual intercourse between the petitioner and the informant. I'm not inclined to indicate. Yes, next. 45.
My application under section 91 of CRPC, particularly on record for contradiction that was rejected by the
Sorry, I didn't follow you.
application under section 91 of CRPC mandate.
Okay.
That is for Someone to.
Annexure 3.
Yes, so someone to produce documents of the or other things, my lord. And that was rejected because the case and counter case in a GR case number period 28, I am the accused, 29 I am accused, or subsequently my FIR is 28 by 21. And one witness that the Tonkadhara was examining chief in our case. I made application to call for that GR case number 328 to contradict the contradiction, my lord.
Yes.
That was rejected by the court of law. It is necessary for petitioner's case and case and counter case and the
Yes, Mr.
Are relying the judgment of the apex court, my lord. Versus that, my lord, these right to reject the petition, my lord.
Two judgments. How will you overcome this?
That how is
no, I also filed a judgment, my lord, that is also appeals court, my lord.
Is it 2023 judgment?
Yes, my lord, that is 91. No, that is 17 officer, my lord. That could have summoned the police record of another case, my lord. Because the
they can obtain the certificate copy.
That's
the better way of doing it.
Better.
no, but
All the documents they can obtain.
Who is stopping you? Why do the entire document will be summoned for you? You get the certificate copy and contract.
Execute it, my lord. During examination, cheap or prior
I can record that and dispose it up. That's a better thing, isn't it? I'll record that part. And I'll record your statement that you will obtain certificate copy of the relevant record.
there are provision, my lord. There are provision to
Don't go by that. There are two judgments.
same.
In accordance with law.
then allow me to present the witness, my lord.
Sita, upon petition
We have to do an application 300.
Because it discussed the
Where is that? You are not, you are only pair is bring that record.
record for process that period, my lord.
recalls the petition
That is the examine.
Counter case is GR case number 320.
Yes.
You want the evidence of one Tankadara. In that evidence, in that GR case to be brought on record here.
This is my lord case and counter case. In that case, I was also informed, my lord.
Tankadara is who? Tankadara is
Independent witness.
independent witness. He has said different versions
My
to.
lord.
I'll take care of it. Right. The land counsel for the petitioner is agreed by the order dated 30th November 2023, whereby his application under section 91 CRPC read with section 145 of Indian Evidence Act has been rejected. And the petitioner in the application entry stated that one Tonkodoro Ponda, who was examined as an independent witness in GR case number 328 of 2021, which is a cross case, has given a completely different version. Therefore, the evidence recorded in GR case number 328 of 2021 shall be summoned, and the same shall be and the petitioner shall be allowed to confront the state evidence to the witness, namely Tonkodari Pradhan, who has been examined as PW.
This PW, my lord.
You don't know.
That mentioned.
Tonkodari Pradhan. The trial court, by relying upon two judgments of the Honorable Supreme Court, namely 1999 17 OCR bracket SC 15 and number which is page 14 and 2023 92 OCR SC 359 has declined the prayer made by the petitioner, paid by the petitioner. Heard Mr. So-and-so and so-and-so. Mr. Ravana, letter counsel for the petition, state submits that in fact there is a statutory bar to summon the statement of witnesses recorded in some other case for the purpose of confronting the
Can be demanded, that cannot be demanded for the purpose of this cannot take into consideration.
rather the petitioner ought to have resorted to different procedure, namely obtaining certified copy and exhibit the same, or confronting the witness, the witness. Letter counsel for the petitioner at this stage submits that he may be allowed to.
He can give suggestion, madam. In that case, you have not stated.
Yes.
He can give suggestion.
Confront of suggestion. Confront of suggestion. Suggestion. At this stage, the learned counsel for the petitioner at this stage submits that he may resort to the same procedure, and after obtaining the certified copy of the statement of the witness, namely Tonkotaro Honda, in GR case number 328 of 21, he would approach the court below for recalling of the witness. Therefore, he seeks liberty from this court. Needless to say that the petitioner has already to resort to the same procedure. With this observation, the petition is disposed.
Now, in that case, here, what I hear, cannot do it.
That can't be clear.
It is a contradiction, my lord. In case of say exit, it is a contradiction.
Let him bring whatever in accordance with law. In accordance with law.
The petitioners are wrestling the very initiation of the proceeding before the executive magistrate for the self-same reason, my lord, when for the same self-occurrence, one FIR has been registered and the petitioner was accused, and here in a GR case, the allegation, my lord, that the petitioners are the protesters for non-disappearance of the funny grant in the Puri district. They demonstrated before the being arrested before the National Highway, for which on 16/10 an FIR has been registered with prior intimation, though they have given prior intimation to the police that we are demonstrating before the National Highway, in spite of the fact that page 17 an FIR has been registered under section 147, 148, 341, other things, right? Other case number 251 of 2023.
Yes.
Alleging that on 16 to 23, the petitioner was made demonstrated and with the hostel with the police and the misuse of the police officers.
Yes.
And GR case is pending. And for the self-same reason, the IIC Southern Police Station intimated the executive magistrate and another proceeding has been initiated. That I am challenging, my lord.
That is the order dated 31/3/2023.
Yes, my lord.
Where is that order? Annexure 4, huh?
Mr. 4.
Yes. Annexure 4. This is what you are challenging.
Annexure 4, my lord, my so-called notice. I am challenging the very initiation of the proceeding.
Let us see what is this order.
My lord.
Page 31.
Page 31, my lord.
21, 22. Yes, 21.
Page 20. Page 21 is plain paper FIR. And I am challenging the initiation of Annexure 3 series, my lord.
Annexure 3 series.
My lord. And yes, the operating person, page 26.
26.
Whereas it appears from the reports,
page 26.
My lord.
26th or 9th?
There is nothing 26.
26 days.
Item 46, my lord, there is shall we say they are even the Palay and others.
Nice. Jharul Islam. Jharul Islam.
Sorry, Balagram, big madam.
Which one you are interested to argue? Tell me. Both the matters are same or what?
No, different.
They say altogether different, nothing to do with it. You are holding two matters here in this court. Oh, here he argued, he picked up another file. Okay, it's all right, no problem.
But here I am challenging the very order that is.
That's what I was wondering. Yes,
I got confused, my lord.
it's all right, no problem.
I am challenging.
Then you come to 21 now.
Yes, my lord.
But mine you are agreed by.
Application for discharge has been rejected.
That's what.
Yes, yes. On the ground that
Hmm.
the bare perusal of the 164 statement, nowhere the victim stated that she was sexually assaulted and she had been taken forcefully by the present petitioners.
161.
164, my lord, I have annexed.
And
There is no single word regarding sexual assault.
what about the other evidences?
Other, my lord, other evidences, the sole culprit.
The case at this stage can't be decided on the basis of only 164 statement. There are many other evidences maybe there, I don't know.
Yes. That's the kind of glance to the page.
164, let us see, 164.
Yes.
In 164, she might not have said.
Because, my lord,
Other witness evidences must be there.
my lord,
How can you be discharged?
in a case, the sole testimony of the victim can be the sole basis of conviction.
Where? Conviction.
So, my lord, my submission is that when the victim girl,
You will be eventually acquitted, that's a different story altogether. But when you be discharged on the basis of only one statement.
my lord, my assumption is that when the victim has deposed in 164 statement that she was not subject.
She might have said something in 161.
Pursue direct for the production of the
What is your instruction? You might have got the charge sheet. Read 161 of the prosecutrix.
164 statement I don't have, my lord. I have the 160.
You should have everything.
Yes, my lord.
161, read it.
161, my lord. My name Sachin Sach, Pita Sachin Sach, village Sachin Sach. ମୋର ମୌଖିକ ବୟାନ ହେଉଛି ଯେ ମୁଁ କଦଳୀପାଲି ସ୍କୁଲରେ ନବମ ଶ୍ରେଣୀରେ
Elopement and what? And she's a child. She's a child. So therefore, it is not a case of quashing. I am saying that you are entitled to bail. Right? So I have been granting bail.
I know.
So if there is something on the petition, I am definitely going to give it. And rather, I would suggest you that I will expedite in view of this trial. Expedite the trial.
I have no instruction for that, my lord.
See, you will be acquitted. I'll tell you, you will be acquitted. And I can say that in view of the contradictory statement of the prosecutrix, I can also say that I'll direct the trial court to examine this witness as a first witness. At least you can be acquitted immediately.
My lord.
That's a better idea. Right on. Petitioner is agreed by the order dated 31/3/2000.
Sorry for interest.
Yes.
There is no contradiction between 160 or 164.
I'll record that. My right on. And a petitioner is accusing so to speak. After investigation, charge sheet has been filed in the present case on.
Procedural file, my lord. It is on 12/8/18.
12/8/18 for alleged offenses under section 366 capital A oblique 363 section 12 of POCSO Act. POCSO Act. The petitioner moved an application seeking discharge. The said application was turned down by has been turned down by the court below by the impugn order dated 31/3/2023. Mr. Mishra, counsel for the petitioners, submitted that the victim in her statement recorded under 164 CRPC has not made a whisper regarding any allegation, much less allegation under POCSO Act.
Regarding sexual assault also. She has not today about sexual assault.
And much less any sexual offense under POCSO. The POCSO. Therefore, even if the petitioner is put to trial, it would be a futile exercise. Therefore, he relies upon the judgment of Gyan Singh and Madhavrao Scindia judgment. and submits that if the chance of conviction in a and the fact scenario of a fact scenario of a case is bleak, then in that and those matters, the court can interfere and even discharge the accused, discharge the accused. Mr. Rahul, legal counsel for the state, has read out the statement of the victim girl under section 161 CRPC. The statement made by the victim under 161 CRPC and 164 CRPC are contradictory to some extent. Mr. Rahul further submits that there are other attending circumstances and evidences pointing fingers against the present petitioner for having committed the alleged offense. Therefore, the question of discharging the petitioner in the fact scenario of the present case doesn't arise. I'm in agreement with Mr. Rahul. Mr. Rahul. There are evidences which are illuminating. There are evidences on record which form part of the charge sheet. However, the statement of the victim is also assumed importance in this present case, because she has indeed not made any specific allegation against the petitioner. In that view of the matter, I'm not inclined to entertain. I'm inclined to give indulgence to the petitioner in this present matter. However, it would be expedient to direct the trial court to do well to see that the victim girl is examined as the first witness. With this observation, the petition is disposed. Yes. First witness, if the victim girl is examined, if she will not support, automatically you will be out. That's a better idea to do it. Case for you. Yes. Thank you. 47.
My lord, the petitioner has been involved in the NBW under Odisha Access Act.
To direct the prosecution to examine the Yes, I have. I can't direct the court to examine the witnesses. It is the prosecution who has to do it.
Yes.
I have given direction to the prosecution to examine it. Yes.
My lord, the petitioner has been involved in the Odisha Access Act, section PP2A, and
Yes.
had issued NBW against him for 10 liters of ID liquor.
Sorry, sir.
For 10 liters of ID liquor.
Yes.
So if if he move a bail may be granted, my lord.
I didn't follow you. I'm sorry.
He has been involved in
It's an NBW arrest, my lord. The 52A of Odisha Access Act, 10 liter
Control here and give you time. NBW, where is that NBW order? Where is that order?
Order 15, Annexure 3, 15, page number 15.
Then Annex 3, page 15, man.
Okay, I'll 16, case 16.
Yes, ma'am.
Petitioner is accused in so and so case. Okay. Since the accused was absent from the proceeding before the court of STJM in CC case number 142 of 2017, the Learned Court below, wide order dated 9/3/2021, issued NBW against the petitioner. Petitioner is agreed by the said order and has approached this court. On the instruction from the petitioner, the Learned Counsel for the petitioner submits that the petitioner would appear before the court on or before 10th of November, on or before 10th of November, and resort to the procedure established under law. Subject to petitioner paying rupees 500, 500 cost. Kept in a mind, sir. Yes. 48 allowed.
May I please, your lordship?
48.
May I please, your lordship?
Yes, sir.
This petitioner's lordship
Hmm.
pray for passing of the FIR order next one, your lordship, against them.
Yes.
The grounds is there, your lordship.
Yes.
There is a two FIR, your lordship.
Yes.
The FIR order annexed 2, your lordship. There we are the informant, your lordship. And so far the FIR order annexed 1 is concerned, there we are the accused persons, lordship. So far the FIR order next 1 is same police station under next 1 is concerned, your lordship. My daughter raced with a motorcycle who was fly by one Manoranjan Giri, your lordship.
Yes.
And accident, my daughter died. Thereafter, lordship, some person taken the dead body of my daughter to the police station and administrated before the police station as to why you are not arresting the accused.
Yes.
The
What
guy
is the stage of the investigation?
my lordship, one thing, lordship, why I am your lordship? How they
As
are
an investigation, what is going on in both the cases?
correct, lordship, I am your lordship.
My lord, one thing is there, and in this case, my lord, earlier this petitioner has granted the bail with the liberty to surrender and
Correct.
What
We are on
is the
bail.
status regarding that also?
He is not surrendered, therefore he is filed.
No, we are on bail, lordship. We are on bail.
Then the investigation is going on. You
No,
have
your
two
lordship,
cases,
glance.
cross cases.
Why
Let it be investigated.
No. Yours I am ready. Yours may glance. What is the how this FIR has been, lordship, drawn in irregular manner? Lordship, the FIR also placing, lordship. This FIR lordship a glance. The Manoranjan Giri, lordship, caused accident to my daughter. But the FIR body of the FIR, it has been stated that the Manoranjan Torei. I am the Manoranjan Torei, lordship. I made accident to my daughter, lordship. This is their irregular FIR, lordship. Then if your lordship that being true, your lordship, then the FIR lordship suffer under annexure 2 is that is gone, your lordship. Lordship, a glance, middle portion of the FIR. Manoran Jamuna Toreke তথাপি 80-90 জন রূপ এবং মহিলা লোক মিশি মনোରଞ୍ଜନ ତରାଇଙ୍କ ମୋଟରସାଇକେଲ ଧକ୍କାରେ ମରିଥିବା ତାଙ୍କ ଝିଅ ପୂର୍ଣ୍ଣିମା ତରାଇ. This is the FIR lordship under annexure 2 lodged by the police, same police station against me, your lordship.
That is true.
The Manoranjan Tori is not the culprit. He has been dashed with the daughter of the Manoranjan Tori. Manoranjan Giri, your lordship. This is the
You see the allegations are 80-90 people of the villages went to the police station, and in front of the police station you have created locus saying that arrest a particular person who is responsible for the accident and all. This needs to be investigated, sir.
I am not in that. I am not in that.
I don't know what is the fact. It has to be ascertained in the investigation.
No, it is the particular word also glance. The particular, the FIR also glance for the spur of the moment. That is from the FIR line.
What is the status of investigation? That is not the to the court.
Also glance. FIR 8 line also.
Whatever. You reserve your right to come after the investigation.
I am ready, lordship. I am ready, lordship. Only FIR from the top 8 line also glance. Line number 8, your lordship. I am placing your lordship.
Item number?
Line number 8, your lordship. The FIR page, your lordship, page 11. The FIR line number 8 from the top, your lordship. ମନୋରଞ୍ଜନ ତରାଇଙ୍କ ମୋଟରସାଇକେଲ ଧକ୍କାରେ ମରିଥିବା ତାଙ୍କ ଝିଅ ପୂର୍ଣ୍ଣିମା ତରାଇ, your lordship.
Sir, I can't say anything on the when the investigation is going on. Not a single word. It is in fact the investigation, the entire investigation.
Why I am assault this FIR?
You want that Manoranjan Tarai should be exonerated by an order like this.
Annexure 2, annexure 2 of the FIR, spur of the moment, lordship. Who is the culprit to make action to my daughter, your lordship? Annexure 2, your lordship, that is there the Manoranjan Giri, your lordship. That is page 15, your lordship. Manoranjan Giri made accident to my daughter, your lordship. Thereafter, lordship, the villagers were taken away my dead body of my daughter to the police station.
Sir, whether it is Manoranjan Giri or Manoranjan Tarai, who knows it? the investigating officer will try to find out.
Same
I
police
can't
station.
give a declaration that Manoranjan Karai is a gentleman and Manoranjan is a crime criminal.
Same police station, same day, same
So
time.
therefore you should be happy that same police station, same investigating authority, and they will understand whether Manoranjan Giri is involved or Manoranjan Karai is involved. How will I give a declaration today that Manoranjan
Because of
Karai is
this,
a very
why your lordship I am
criminal?
arguing? Because of this defect, your lordship, I am unable to get rid of the financial benefit from the Tahsildar, your lordship. That is the unnatural death of my daughter. This is the reason, your lordship.
When can, what is the stage?
And if your lordship say, I may take the
Let me
instruction.
clarify, your lordship. If your lordship.
No, I'll record your statement that we will expedite the investigation. Because see, because of the pendency of this, he is facing a lot of problem. That's what he says.
Yes, my lord.
I'll record your statement that the investigation will be expedited and distributed. This is, I think, this should be fair. Isn't it? Because the consequences are there, I'll not write anything because investigation is going on. Dispose it up with a direction to expedite the investigation process right now. The petitioner in the present petition is seeking quashing of the FIR number 189 PS Talchua Marayan PS case number 189 of 2023 corresponding to GR case number 811 of 2023 on various grounds. Particularly the Mr. General Level Counsel for the petitioner particularly highlighted that there are two cross cases pending in the same police station. The facts described in both the FIR are contradictory to each other. Therefore, relying upon the second FIR, namely Talchua Marine PS case number 187 at 2023, he seeks quashing of the FIR number 189 of 2020. 189 of 2023. Mr. Rahul Level Counsel for the state submits that both the investigation in both the cases are still on. Therefore, he submits that at this stage, interference by this court may not be called for. I'm called for next program. Since the investigation in both the cases are still going on, I am not inclined to give indulgence to the petitioner at this stage. However, suffice it to say that the which police station is this? Talchua. Suffice it to say that the Talchua police station should do well to see that the investigation of both the cases are concluded as expeditiously as possible. The petitioner is granted liberty to resort to remedy under law after the investigation is completed. Free copy. Yes.
Will come pass over.
Okay. Yes. 50 passover. Yes.
51.
Council mentioned December.
52.
Whoever will seek adjournment, give it in December and note it down. Again, will mention, then don't exactly it. Yes.
Hello, 52. Here, my lord, there is a case where I am challenging for initiation of the proceeding.
The one which you are partly arguing.
Yes.
Yes.
Let's see what happened in this case. During the super cyclone Phani, the entire Puri district was affected, and some villagers were deprived of getting the benefits of the funny benefits. So with prior intimation, they protested before the National Highway under the Puri Sadar police station. And after demonstration, there was discussion between the protesters and the police officers. And when the discussion was going on, some protesters misused the police officers, and for which an FIR has been registered by Puri Sadar case number 251.
Okay.
Under section 147, 148, and
Writing and all.
yes.
Hmm.
For the self-same reason, on what happened in 1610, the IAC Sadar police station intimated the executive magistrate, and the executive magistrate again initiated proceeding order 107. That I am challenging, my lord. Self-same reason to proceeding.
What is your prior impression?
Yes,
Yes.
yes.
Same person or many other persons?
Lordship, it is 1411 2023, incident in 1610 2023.
Sorry, I am not follow. Sir, 14?
1411 annex at page 12, Lordship.
Page 12.
Yes.
Yes.
8 आगो देखो क्या आगो पुरी जिला
11/2023.
Yes.
Yes.
सेटा क्या आगो पर subsequently.
And what's the exact date?
This is FIR is
1 FIR is
1610.
regarding 14/11/23 incident. 16
It
FIR.
cannot be because prior
I am clear. The FIR is regarding the incident taken place on 1610. But you kindly glance at the page.
What had happened then 14/11?
1411 just after demonstration, some written communication to the collector.
Okay.
And FIR has been registered on 1610. Allegation that, Lordship, I am reading page 21. Page 21 of the relevant person.
1 minute. 21. Okay. Yes.
The allegation on 16/10/2023 at 5 p.m. received written report sent by IOC through ASIS Malik. On this report, I registered PS case number 251 of 23 and directed to SI DK Panda to continue investigation of this case as per arrangement by such and such. My lord, the allegation that the agitators blocked the NS 316 from supervisor from 12:10 p.m. to 2:15 p.m. After long persuasion by the police and magistrate, they lifted the blockade at 2:15 p.m. as the above leaders went to collectorate Puri for discussion with senior revenue officials. Once again on 5 p.m. Ashok Nanda, Govinda Mahapatra,
All the people. All the people.
Yes, my lord. This is the incident on 16.
And about 600 others.
Yes, my lord.
Block the road, so and so.
My lord.
They obstructed the movement of the public service, so and so. This is the FIR.
This is the FIR.
And where is this?
Yes, my lord. This is page.
No prior intimation.
Next.
Page 26, my lord.
26. Yes.
Self allegation, my lord. Whereas it appears from the report submitted by IEC Puri Sadar.
Where are you reading?
Page
26. Whereas it appears from IIC so and so.
Second part is hostile term with the first party members due to mass demonstration on NS 316 in front of the Maruti Party.
Satisfied on the content of the police station.
And the magistrate has initiated proceeding. He will initiate. Where is
the legal bar?
My lord.
Where is the legal bar?
Self-same offense, my lord.
No, maybe. Where is the legal bar?
My lord.
You show me the legal bar.
My lord, I will sir. I will
There is no legal bar.
Yes, my lord, legal bar. Because once for offense, FIR has been registered and I have been accused and I have already allowed him bail.
It is 107 is only for breach of peace. You may do it once again. Therefore, 107. You have to bond and go once. That's all. Preventive matter. Preventive. Only may happen, may occur. So you have to give a bond that you will not do it. That's all.
Penalized section, my lord. This is the penalized section, my lord.
Lord, I am satisfied.
No. What are you? If I put one coaching, then you will ask for adjournment. Again, you will come. I will put. Where is the legal bar? You are such a seasoned lawyer. You know.
Lord, I will answer to you, Lord.
You answer it now. I'll pass it over. Answer it. There is no legal bar. And this is the right procedure to be initiated and rightly it has been done.
But if proceeding could
you are not expecting this question from me and I am passing over.
if proceeding if proceeding is initiated, prior procedure of a metropolitan different. They have arrested religion bail subsequently.
The best part is a seasoned lawyer like you knows the answer. You know the answer, but you don't want to answer that.
I am not a single lawyer, my lord.
2 o'clock. Come and tell me any legal bar, then I'll definitely.
Tomorrow.
Tomorrow, you see, the problem is tomorrow I want to streamline the listing process.
Tomorrow, my lord, tomorrow.
Try at 2 o'clock, it doesn't happen, then I'll do it. Don't worry. Try at 2 o'clock, not exactly 2 o'clock, means about 3:30. You come at 3 o'clock.
2 o'clock, my lord. Okay.
2 o'clock. If it doesn't happen, then I'll definitely do it. Only just see 107 and there is no legal bar, and then tell me, yes.
53.
Adjourn. But we'll go to December, sir. Adjourn, December.
54.
Yes. Pass over.
55.
If I note, this matter is connected to Division number 92 of 2024. There, that matter has been assigned to court number 17.
Yes.
Presided by Under Justice Nursing.
Selection is there.
Yes.
Serialship, brother. Serialship.
That, in that revision, I am challenging the order of framing charge. This CRLMC law, I read to recall that order of framing charge and discharge me. Both are same. That, in fact, that is the main matter.
Okay. The lordship can
No, he says that charge has been framed.
charge when trial commenced and evidence.
Now, this case he wants to rather you do this thing and prosecute the and whatever points you have taken, I give that liberty to add those points there if you want.
Yes.
That's a better fair idea. Right on. Learned counsel, Mr. Pradhan, learned counsel for the petitioner seeks to withdraw this petition to urge all the points raised in this petition before the coordinate bench in
Criminal Division number
Criminal
92 of 2034.
93 so
92 of 2024.
and accordingly he seeks to withdraw the present petition with the reserving the same liberty disposed of as liberty is spread. Yes.
56. 56, no?
Yes.
Recall petition has been rejected, no?
Recall of the witness
The recall of witness now PW7, PW8.
789.
Yes, PW7 is the son and informant. PW8 is the investigating officer. PW9 is the medical officer.
307.
307, the accused is the father. Son is the informant.
Yes.
So, the
Why are you not cross-examining them? Decline.
material points have been.
13 for 23 LCB.
Huh?
13 for 23 last cross-examination are there. Then he has filed the application on 4/1/24. After lapse of 8 months.
The learned trial court says, I have not specified the questions, relevant questions to be asked. So say,
The same date, any application should be there, basically,
Yes.
not after 8 months.
And the questions are framed.
Yes.
Questions you have framed.
yes. At then, Annexure 3.
Who is out of these 3 witnesses? Who is the most important witness for you?
Seven.
Seven.
Seven is the informant. Because what the prosecution case is that the father is the accused.
May I have asked for the purpose?
No?
I will allow insofar as 7 then.
Your
Will it suffice?
PW8 is the IA. PW9 is the doctor. 307 case.
And also have a going to page 37.
Relevant questions, I have to put relevant question to the witness, informant. I have to put to, in that line, I have to cross-examine the IU also.
IU also. Yes, yes, what do you say?
All the three. Yours are
Let's
three.
look at the page 37.
37.
Yes,
Okay.
let's see what order serials.
Yes.
Last paragraph. With the record, it is seen that PW7, PW8, PW9 are examined, cross-examined and at length
That is-
and discharged on 59/21.
That can be done.
11/10/21.
They can.
14/4/22.
That's what notes, I am relying on the decision of.
No, no, what reliance, what I, see, let us do one thing, give one, because see, the accused has an indefensible right to defend. One opportunity,
Right.
one opportunity, to examine all the three witnesses on one day without adjournment.
On the sole point, you know, paraphrase.
I am going to give you one opportunity, one day without adjournment.
Yes, sir.
You do all the three witnesses examined.
Because the dispute has been amicably settled between the parties out of the court. That is why the recall is necessary.
Don't say that I made it.
That is why the
Petitioner
recall.
is agreed by the order dated 20th January 2024, whereby his application under section 311 CRPC for recalling of PW7, 8 and 9 has been turned down. PW7 is the informative
Informative.
case, whereas PW8 is the IO and PW9 is the medical officer. The petitioner, being the accused, moved the application seeking recall of the witnesses. And in the application, application, the questions to be put to the said witnesses are enumerated. The Lenna trial court rejected the application primarily on two grounds, namely the witnesses sought to be recalled. I have already been examined at length in the year 2021 and 22 and has been discharged, and therefore the belated stage they may not be recalled. Apart from that, the trial court has also observed that there is no questionnaires enumerated by the petitioner in the application. I have perused the application and the evidences for those witnesses. I am of the considered view that the petitioner is entitled for a singular opportunity for cross-examining the aforementioned witnesses. Accordingly, I allow the prayer made by the petitioner, direct the trial court to afford one opportunity to the petitioner to cross-examine the said three witnesses. It is made clear that the petitioner shall not seek any adjournment on the adjournment and cross-examine all the three witnesses to be recalled. The trial court shall also examine the relevancy of the questionnaires to be put to the witnesses. If in any case the petitioner fails to cross-examine the witnesses on the single opportunity provided to him, he shall forfeit his right to cross-examine. Accordingly, the petition is allowed. Yes. Yes.
57. My lord, I have filed the note press memo, my lord. I have filed the note press memo.
Yes, thank you. Yes.
58.
The include order is at page 9, Lord.
9.
Page 9, Lord. I filed this application due to the rejection of my 311 petition, Lord. To recall, witnesses number.
Sir, you accept this in order, you have not filed your application, you have not filed anything. How will I know?
Yeah, Lord.
What was your application? When you was cross-examined, nothing is there. Except in order, nothing is there.
Your Lordship, call it in the next week. In the meantime, I'll file. It's telling rejection of it.
Only rejection order. This is nothing.
So everything they chance. Se mona korchandi. Other co-accused person examine hele, cross-examine hele. Se nije mona kale. It was closed. Now, at this stage, seven question, but then outside samastomo recall. only 2005 मसीहाରେ କଣ only to procrastinate the trial. That is my
2000 when these witnesses were examined.
this ଜଣେ ହେଲେ 22 ରେ ଜଣେ ହେଲେ 6/10/2023 ରେ
8/2022 PW3 then 6/10 2023.
Why you decline what to do? That's what is the offense, by the way? The FIR is also not
31D 120 yes. ଅନ୍ୟ କୋ accused ମାନେ
where from you got 31?
ସେ ଲେଖା ଅଛି.
FIR is not there, nothing is there.
Page 3 may not have it. Page 3.
Case 3. 3 of
My petition.
or your petition. I have to believe you. When the criminal cases are to be decided on the basis of pleading.
Your Lordship may call us in the next week. I'll file all those relevant.
How do I know that you are accused of what case?
I understand.
You may say whatever 302, you may say whatever. Cases are not decided on the basis of pleading, you must understand. You are wasting time. Shall I put? I'll
Lordship may call.
I'll adjourn it subject to cost. Give one opportunity. Up to 1 week. File relevant documents, okay? Yes.
59. 59.
I have obtained the charge sheet copy. Your Lordship keep it to next week. I will file this same before the court.
Today is first day, therefore I am giving. Henceforth I'll tell you why. The reason is, don't take it otherwise. The reason is about 700 matters are pending. I got it today in the morning. Not even listed once. I'm adjusting every day. If I'll adjust about 50-60 matters, I think within 15 days I can attend all the matters. If the matters are listed and you seek adjournment, we'll go to December.
ଏଇଟା ନେକ୍ସଟ ୱିକରେ ଆସୁ ମୁଁ ଫାଇଲ କରିଦେବି ଆଜି ଫାଇଲ କରିଦେବି ନହେଲେ ଏଇ ୱିକରେ କୋଉ ଦିନ ହେଲେ ଆସୁ
But in other matter, if you file this type of matters, then make it sure that it is next.
ନାଇଁ ନାଇଁ ନେକ୍ସଟ 49 also same my lord
After one.
49
See, that's the
ଆଜ୍ଞା
then if you
ଫାଇଲ ଚାର୍ଜ ସିଟଟା ନଥିଲା ତ 49 also same next week
yes 49 pass हो रही थी ना
ହଁ ସେଇଟା ବି ଚାର୍ଜ ସିଟଟା ଫାଇଲ କରିଦେବି ଏ ଦିଟା
okay okay after 1 week दे दिया next yes yes
Item 60.
This application has been filed on the ground for quashing of the entire process on the ground of delay, Lordship. At a glance, the FIR drawn, Your Lordship, in the year of 2004, that is 18/5/2004, Lordship. Charge sheet submission 27/5/2008. Cognizance taken T6 2008. As and today, no proceeding at all, Lordship, are still, Your Lordship, the file is pending. And we are on bail, Your Lordship. And the proceedings so far continuing since 2004. Now it is 2024, it is 20 years in the mean it became elapsed, Your Lordship. No proceeding as well so far trial has been commenced as of today, Lordship. So there is a Katina decision of our own High Court, so far the Supreme Court, Lordship. As a deliberated international delay, then the
Mr. Gada, case 2004 FIR, 2008 charge sheet is filed, nothing.
What happened in this case, my lord?
Yes.
This petitioner, my lord, Dikshit, my lord, P. Dikshit, my lord, and Ashok Mishra, Ashok Das, VK, Balar Singh, were arrested and followed the court. The rest of the accused persons, Professor Pandav Naik and New Delhi, my lord, and VK Mahanti, my lord, they are, my lord, the Jamshedpur, my lord, they are the who are the beyond the state have not been arrested, and the case, my lord, pending, my lord, the investigation pending against them, my lord. But if he file the petition, they are split up the case, and then everything will decide.
Why should I?
Want to file this split up petition, madam?
Why should I?
Against them and success of them, madam. With regard to process, madam, since they are outside the state, madam, Jamshedpur and the New Delhi, madam, but for that they have not been arrested, madam. And success of
My task.
you have to file my petition, they are split up the case, madam.
Why should I? When there is a law provides me, Your Lordship, the ground of delay.
And he waited,
What he says is split up is one issue.
madam.
That will be the future course. If at all, I am not agreeing.
Only because
What he says is 2004 FIR, 2008 the charge sheet is filed,
madam.
and till today nothing is happening.
They are filing 370 petition and taking time, madam.
No, not at all.
Unless until this case is split up, madam, since investigation pending, madam, against the poor persons, madam, the case cannot be trial cannot be concluded, madam.
But why prosecution hasn't done it?
But they have filing 370 there, my lord, before trial court.
After instruction, if 370
All the rest, my lord, may be confirmed, my lord.
See, I like to see whether the delay is attributable to you or not.
Report also.
Correct, your lordship. If the delay
You, then you may have a
on
case.
my behalf, your lordship, then also I have no case.
I'll
Yes,
simply
yes, good.
don't issue notice, simply say Mr. Ragada and Mr. General led counsel for the petitioner submits that the petitioner is an accused in FIR registered in the year registered on 18/5/2004. After investigation, although the charge sheet has been filed on 27/5/2008, the trial has not proceeded yet. Therefore, he seeks quashing of the entire proceeding. Mr. Ragada, learned counsel for the state, submits that the attributability factor needs to be ascertained. Therefore, he seeks 1 week time to file the proceeding before the trial court. Leaves the matter after 2 weeks.
So that may be, orders may be confirmed, but I will file.
And the trial court is accordingly, trial court is directed to transmit the proceedings. Proceeding of the court case number, proceeding pertaining to the case number, so and so. By next date of hearing, leaves the matter after a week or so, 2 weeks. I'll just come.
But and at that time, my solver qualified need.
After investigation, your name will be tracked down.
But that of a union SCST notice notice.
Okay, he should notice. Yes.
Special
messenger. OP2. Special messenger, and after 1 week. You take it after 1 week. Yes. Chance of
compromise. That is only because guilty persons FIR against 80%.
You file it by tomorrow so that day after 1 week log in here so that we can see. Yes. 62. Yes. Withdraw. Okay. Who passed away? Petitioner. Okay. For the petitioner submits that the sole petitioner in the present case has expired. Hence the he needs to withdraw his petition. Yes. Yes.
63.
63. Pass on. Okay.
64.
May I please, Your Lordship?
Yes.
So the petitioner happens to be an elderly lady, aged of 50 years.
Yes.
The tenant has given the FIR against, lodged the FIR against the present petitioner. The Lordship can come to
opposite party number 2 is the tenant.
Yes, please.
Okay.
The wife of the tenant. And was FIR was not
you are a civil citizen.
not senior, 50 years old. This was all the four family members of the petitioner, having the petitioner's husband, and petitioner's son and daughter. All were named in the FIR. At page 11, you also will get it. But after filing it, while charge sheet was filed, the petitioner already found that 3 persons are no involved. Even the principal allegation was in his son, who was reading in class 11, and he has been also discharged.
Okay.
And cognizance has been taken against the lady on the allegation. Allegation is that he was the present petitioner entered into the house of because she was a tenant. She demanded money because she was not paying money. That one money should is also pending, and that's the reason why allegation is she entered into her house and phone her mobile phone. That is the reason why that has been broken. And 27 allegation has been made. And as because she entered into the house, there is 341 is there, and she has assaulted her, given some blows. That there is 323 is there.
You have initiated eviction petition, eviction proceeding against her.
Yes, we wanted the rent. They were not paying rent.
Notice.
You serve up to 1 week. Yes, issue notice. We'll try to. Have you initiated any proceeding for eviction?
They have left the house.
Well, let us settle it and finish it.
They have left the house and because of one suit is pending for
recovery.
for money because the damage
Recovery for rent, how much?
was that I have not exact instruction I have not got.
You tell me so that both the suit and this everything will be squared up in one go.
I'll take instruction.
After 1 week, issue notice, file the process immediately. After 1 week, and get ready for settlement. And secondly, see, they have vacated the house.
Yes, they have vacated. It is
of money. What?
Yes, of course, there's a, I mean, I am the opener once husband and lawyer. That is the reason why.
Why are you insisting for vacated? And you withdraw the suits, you withdraw the criminal case police. That
And
Monday.
and discuss there and also can listen.
Monday, 28th. 28th, we'll finish it up. Yes.
65.
Take notice, immediately. Yes.
My lord, this is a Belgium case, my lord. On that 28/2019, the land JMF issue NBW due to the non-attendance of the acquit petitioner, my lord. Any condition may be, any order or direction may be imposed, my lord. Offense 341.
28/8/2019 NBW issue, my lord.
Only
2019 NBW.
as NBW. So, by the order dated, petition is accused in so case. By the order dated 2019, NBW has been issued against the petitioner for his non-appearance in the court. On instruction from the client, then for the petitioner submits that he would surrender before the court. On or before surrender only will appear before the court on or before 15th round. And this to the remedy will be done. Cost something 500. Yes. 500 cost. You pay to each go with Kalani, Kalani District Bar Association. Kalani District Bar Association. Yes. 500. Yes.
6. Quashing of cognizance, my lord.
Cognizance.
My lord. 372I. IPC and POXO.
Pass over. Pass over. Yes.
67.
Yes, sir.
But I have challenged the annexure 1
Yes.
dated 28/2024
Yes.
passed by the London Sessions Court, Kendrapura.
138. Where the accused. Where the accused.
And that issue.
Yes. What has happened?
I am appealing.
Directing the petitioner to deposit at 20% of the awarded amount.
That's the law.
By the trial court.
That's the law.
And in that respect, my lord, your previous assigned lordship, Honorable Justice Mahapatra has passed an order set aside the order of the London Appellate Court.
That's the statutory requirement what to do.
No,
The only thing what could be done is you can pay it on installment basis. That's
I
it.
have cited one judgment of the Honorable Apex Court, and Honorable Justice A.K. Mahapatra has also referred to that judgment. In that respect, I am
showing
one order is there that has been reported in ILR July issue.
What does it say? It can be cost.
Set aside the order of the.
But facts of that case may be different anyway. Show me which part.
Para 7, my lord. And in para 8, set aside the order.
No. Where is that Supreme Court judgment?
My lord,
Cited.
my lord, annexure 5, my lord, in my petition.
Yes, what was your defense?
To set aside the order of the.
No, you have to see, the Supreme Court says that you have to see whether the on merits also, prima facie case on merits also you have to see why.
Comes under the exception.
Ah.
Comes under exception. My lord, my contention is that the complainant deposited the check on 31/5/2019. Bank return memo he has received on 8/6/2019. And he has to serve notice within 30 days from the date of receiving the bank return memo. But he has issued notice on 22/7/2019 after 52 days. This is my contention.
Okay. Yes, what do you say?
My lord, of the judgment was passed on 19/1/2024, directing the petitioner, my lord, to deposit 5 lakhs to the complainant as compensation under section 357 plus 3 of chapter my lord, for appeal. And in appeal, that as per the provision, my lord, it was directed.
So that's I understood the fact. He is relating the judgment of Supreme Court in criminal appeal number 2741 of 2023 and also relying upon one of the judgment of the coordinate bench in this matter. Have you seen? He says
No,
that
my lord, he has not served the copy, my lord.
I'm just issuing notice. Just see whether he is covered by this judgment or not. According to me, he is covered because he is raising a question of limitation of filing the case, you know. So therefore, he may be covered by this judgment. So I'm just issuing notice.
I am appearing in 3 cases, my lord. That petitioner is same and the opposite complainant is also the same. I am appearing in 3 cases. So let my friend, my lord, hand it over those copy to me. And
along with the copies of the petition, along with the judgment which you are relying upon. I'll just examine to that extent whether you are covered by that judgment or not.
Judgment to pass to similar court, my lord. Appellate court Kendrapada. Is that judgment of appellate court?
He says that he doesn't have.
I am also telling that order of the appellate court.
Original court is STGM Kendrapada. Original court is, my lord, STGM Kendrapada. Order was passed on 19/1/2024. Thereafter, before appeal before the district and session judge, not in the same court. That original court is not the same court.
Now appeal is admitted.
Yes, well, appeal admitted and direction was given to deposit as per the statute. As the my lord.
See, well, at the complaint stage that is 143. In the appellate stage 148. And 148 direction is made as per the statute. But there are 2 judgments which he is citing. One is from this court, another from Supreme Court. He says that this is not mandatory.
Yes, my lord. But my
so therefore you check it up. Okay.
Till date, my lord, he has not complied the order of the appellate court. Till date, my lord. Till date, my lord.
Challenging that order, why should he comply? He challenging that order, obviously. He will not comply. Yes, he should.
I is there.
1 week after. 1 week after you just see.
And my lord, copy of that judgment along with the copy of this.
For the petitioners, I'll supply the entire papers pertaining to this case along with the relied upon judgments to the counsel for the opposite party. Yes, next.
68, 68, 69,
68, 69, 67, 68, 69.
69.
You should notice, which it on 29. 29. What is the check amount in all the three cases, sir?
5 lakhs.
Check amount?
Awarded amount or
5 lakhs.
Check amount.
check amount? Well, check amount is in item number 67. Check amount is 3,09,050.
Yes, yes. And the other two cases?
Other two cases, I am ready.
Just give you a fair idea. About 9 lakhs, I think.
About 9 lakh, 9 lakh some odd.
20% of 9 lakhs.
Well,
In at least in one case you give, one or two cases you give, other case are exempt. So there will be a balance.
it is a clear exemption of Honorable Supreme Court.
If I find a case, then only I will give the benefit of that judgment.
And I am coming under the exception category.
That's right. I have to examine whether Prabhasa case you have or not.
Well,
So let us see.
Since my lord 2019 he was cheating me.
Is there any chance of settlement?
My lord,
No,
yes, one, because I am the my lord.
yes, the applicant has subject so many facts, my lord.
Okay, that's right. Okay, there is no chance. Okay. Yes.
70.
My pleasure. My dear, the case, my lord, the petitioners are the father and son, my lord. Your lordship can turn to page 32.
Petitioner?
Your lordship can turn to page 32.
Who is father, who is son? Petitioner number one. Who is the father of one?
Yes, ma'am.
Yes.
And your lordship can turn to page 32.
32.
Yes, ma'am.
Yes.
On 21st February 2024, the petitioner number 1 lodged the FIR against the informant and her husband under section 420 and 34 of Indian Penal Code, Lord.
Against the informant.
Yes, Lord.
Yes.
The informant and her husband, Lord. The main allegation is that 3 lakhs transferred to the her account regarding the purchase of land, Lord.
You have 2 lakh rupees you have like to the informant.
Diploma.
You file an FIR. Yes.
And your lordship can turn to page 21.
20?
Page 21, annexed to 2 series. Accordingly, we have prepared a demand draft of rupees 39,902 in the favor of the DSR Kemsar, and the shell deed were also been executed on that time, 23 Lord. And the surprisingly,
you had sold the land to the informant.
yes, ma'am. Now, your lordship, the surprisingly on page 16, annexure 1, I am challenging that the FIR, Lord. After 2 days, Lord, on 23rd February, uncertainly the informant, who happens the wife of the petitioner number, informant, accused number 2, Lord, that entire allegation against me, that 341, 294, 506 and 34, Lord. I am the practicing advocate of the Kemsar Bar Association. And now, what are the allegation? Allegation only for the hotel Jagapni Kinavika Chalsila. I am giving 2 lakhs and 1 lakh Google Pay, 3 lakhs already. By that time, the salary was, but investigation is going on. Yes, Lord. That investigation, what are the status of the investigation? I don't know, Lord. That after.
Might have been charge sheet filed in the meantime?
No. My instruction of charge sheet has not been filed.
See, apparently there is a lien, property lien. There is a case he filed against them.
Yes, Lord.
And it's a cross case. What happened to both the FIR?
420 million.
No, that is for
Against the wife million. 5 to 94 million.
no. Why from the behest of her husband?
He given a witnesses million. Name of her there. So, at least Justice Mehta issue notice to the private practitioner.
And if you notice and get the status of this case,
Yes.
because he says that one lawyer is
The petitioner number 1 is practicing.
License to million.
That's
Actually, that is possible. This type of.
No. I heard the paragraph.
lawyer not seriously practicing.
No, I am aware the paragraph 2, Lord.
I'm just issuing notice.
Yes.
I'm just issuing notice and get the status of the case. Okay, issue notice after 1 week. Yes.
71.
Your lordship may call this matter on Friday. I'll file a consolidated cost item along with a miss case, my lord.
Like what happened?
My lord, what happened in this case, it's a case under section 506, where charge was paid.
Yes.
The petitioner has challenged that charge, my lord.
Hmm.
Earlier,
Hmm.
the complainant filed one FIR
Yes.
under section 506, 34 and 3 of SC Act.
Right.
On the allegation that while she along with her brother-in-law was returning on a motorcycle, this petitioner scolded him near Kamapalli overbridge. On that allegation, FIR was lost. During course of investigation, the police has tried to trace out the mobile location of this petitioner.
Okay.
On tracing, my lord, it was found that on the relevant time and date, the petitioner was in Bigapandi or some, which is near about 30 to 40 kilometers away from the spot. So he has given final PR as false FIR and closed the case.
Yes.
Against that, my lord, after sitting over the matter for 6 months, the complainant filed this present case.
This petition.
Under 202, it was recorded, 161 was recorded, and cognizance was taken and subsequently charge was filed.
So what are the grounds?
Grounds, my lord, the grounds is that I was not present even as
That's the police. The plea of alibi was accepted by the police. Despite that,
Let
us see the complaint whether this case is made out or not. I'll have to just see the cognizance order is correct or not. That's all.
What is that? After framing charge, my lord, that was stalled. That was stalled.
No, stall how?
My lord, earlier this petitioner is approached this Hon'Ble court during cognizance stage in 2014 or 15.
And what it say?
No, the Hon'Ble court has directed you raise all your objection at the time of framing of charge.
Yes.
That was disposed of. Thereafter, after framing of charge, my lord, I have come.
Now let us see what are the allegations against.
My lord, the allegation, my lord, I have filed the complaint petition.
Except a plea of alibi, you have nothing.
Yes.
Plea of alibi is a
Plea of alibi, and the second thing is, my lord, I am an retired assistant teacher. While I was a teacher in Conesi, some school, this complainant was the headmistress. And there was a dispute between the parties, for which this petitioner has filed one WPC before this Hon'Ble High Court as well as one CC case before the SDM Barampur.
Yes.
So she always tried to get over me and always threatened to do those cases. And when I was not ready to do
these are factual disputes.
Yes.
How in the charge stage, what can I do for you?
When the police says, my lord, my mobile was, yes.
Therefore, there is a procedure of filing a protest petition. She has filed a protest petition, made some allegation. 202 inquiry has taken place. She made those statements, reiterated those statements. On that basis,
statement of brother-in-law and
any wrong or right that will be tested in the trial only. You are only pleased the plea of alibi. Plea of alibi. Plea of alibi is a question of fact to be determined in the trial only.
As per the allegation, my lord, if you also kindly glance to page 18.
You tell me, forget about, you don't have a case on merit. Otherwise, you tell me, is there any chance of settlement? Because the allegations are very minor allegations.
Minor allegations.
And the complaint and he also teach you
also may issue notice if you will agree, then you will also make a suit.
You have to make her agree.
I will take instruction.
I just issue notice, let us see.
My lord.
Simply issue notice. Returnable after 2 weeks. Yes.
72.
It will for 1 week time. Not 1 week, 1 month.
1 week.
It will go to December. Okay. Adjournment means December. Huh? On request, adjourn to December. Yes.
73. May I please your lordship?
Yes, sir.
Well, this is a appeal against the order passed under section 3 and 4 of criminal law.
Fresh appeal. Is a fresh appeal.
Criminal law, my lord.
I know it is a fresh one or what? Fresh appeal.
First one, my
Yes.
lord.
Sentence?
No, second attachment.
Oh, attachment.
Section 3 and section 4 of criminal law amendment.
Attachment.
Third person has come to this court claiming the right title interest of the property, which property was attached during in course of the trial till disposal of the trial. That order has been challenged. Criminal Law Amendment Ordinance, Section 5.
My lord, this case has been arisen out of vigilance case number 35 of 2002.
You are the,
I am not the accused person,
Yes.
but my property has been attached.
show me your application and what is the order first.
The prosecution's filed petition that is under annexure 2, my lord, at page 38.
Mhm. Come to the impugn order. Which is the impugn order?
Impugned order is 156.
Page 153, my lord, annexure
153. Yes. What are the reasoning?
the operating portion, my lord, at page 155.
Yes.
On examination of the entire materials and paragraph C appears that the civil property acquired by the opposite parties is disproportionate to the known source of income of opposite party number 1. And existence of apprehension is that the opposite party may alienate or transfer the sum, which will definitely cause irreparable loss and prejudice to the state. But so far as the finding that the actually either disproportionate to the known source of income opposite party number 1, this is unfounded. There is not a single clue, not a single evidence on record or during investigation so that the property has been filed from the income of the accused of the opposite party number 2. The entire any properties property has not been attached. So it has not been seized. That is not been found to the proceedings. What are the property that page 54 annex
Page 32, serial number, page 32.
32.
In the charge sheet, serial number 1 and serial number 8. 9.
Serial number
1 and 9.
page 32.
1 and 9.
The property and the construction on it.
At serial number 9, it has been mentioned cost of the one piece of land by plot number 604.
First, let me read there.
Ah.
Oh, up page 32, huh?
Page 32 at serial number 9. The cost of the one piece of land by plot number 604, khata number 73 in plot. My respectable submission is
And there are two properties. One is one. Value
In over one, construction has been made by the 9.
and one property. Yes.
but they are not seized either the land requested by borrower or the sold it. Now let us come to page 56. What are you doing by the way? This property has been purchased by me from the money given by my maternal grandfather who is bankrupt. That comes part of record.
Okay, sir, I know. How will you link it? Tell me.
Your Lordship, this is a disputed question of fact. The property was purchased when this petitioner and his brother were minor.
Okay.
Your Lordship may kindly have a glance to the sale deed itself.
Yes.
Page
51.
Page 56.
56. Yes.
The age of this petitioner may kindly be perused, 14 years.
What is the relation between this accused and the Yes, yes. 14 and 12.
14 and 12. The check period is from 1/1/90 till 31. Your Lordship may kindly have a glance to the charge sheet, the check period. The check period is 1/1/90,
1190.
1/1/90, page 31.
92. The sale deed is
One, your lordship, 31/1/2004. First paragraph is alleged in FIR 1192, 31/1/2004.
Sale deed is
This sale deed
94. 28/10/94.
Sale deed has been registered in 7/10/94 within the check period. Let me place some relevant facts and records. Till then, my lordship, your friend may be.
Yes, definitely. Still.
Page 56.
Yes.
And my lord, may precisely come to page 63. That in consideration
Name of the accused?
accused name is Arjun Charan Rao.
Okay, okay.
And the petitioner is Alok Prakash Rao.
Yes.
That in consideration the payment of the sum of ₹80,
Reading, sir? Which page you are reading?
page 63, my lord.
63. Okay. Yes, read it. Yes.
That is how I am going to show a bankrupt has been made by the maternal father of the petitioner. Who has purchased the land in the name of his grandsons, two grandsons, out of love and affection, when there is no glimpse of truth. That in consideration the payment of sum of ₹81,000 only in shape of bank draft by Sri Gajendra Rao, the maternal grandfather of the purchaser, out of his own funds to the vendors at the time of
What does the Gajendra Rao does?
Gajendra Rao was the employee of forest department, working over Tata companies. And the law court has rejected the objection on the ground that there is no document file to show that Gajendra Rao was employee
Independent source of income
of a Tata company. But this is a piece of evidence where a bankrupt has been made from the account of Gajendra Rao.
But source of Gajendra has to be established. How he has made a draft in the name of the grant.
One affidavit was also filed by Gajendra Rao to that effect. That is at page 134, annexure 10, madam. And I am a taxpayer. I am obtained loan from the bank for construction of that land. And that CBA approval for construction of that land, all with my name. Our liability to you obtain loan to give gift. No, loan on my personal capacity. After I am being a taxpayer on my personal capacity.
How many children this Gajendra Rao has?
Gajendra Rao is maternal grandfather.
How many children are there?
Gajendra Rao, the maternal grandfather. I have no instruction to that.
So that is very relevant.
That's very no. That's only that, my lord. Oh, I have just forgotten.
Where from I'll get it? That only that. Where does it say that I have only one daughter and I have only two minors? I'm getting gift by obtaining loan from the bank.
But affidavit was stating that my daughter was not only daughter was written.
That's the relevant facts. Those things should have been established on record.
That is fact. I will
on the basis of presumption, it can't be done. And rightly the trial court has confiscated.
That is fact. I will produce the relevant things before your lordship.
But in the appeal, I can't go into all these things.
Let us President we call for. Let us show a single fire. Single fire of Arjun Rao has been invested so for acquisition and construction of a property. So for construction is the house is concerned, documents are there, loan documents are there. I have been at it.
Obtained loan.
I obtained loan from Allahabad Bank. That is the page of annexure 1.
Transactions are very doubtful.
Let me permitted to submit a few lines. I am referring to the affidavit, their affidavit. Your lordship may kindly have a glance to page 145.
145?
Affidavit.
Oh, 1 minute.
After my editor.
Yes. Yes.
The amount may be seen for a consideration of rupees 1 lakh.
Which paragraph you are reading?
First bar after my return. Middle.
That my daughter Srimati Jyotsna Rahul.
145. 145.
Okay, after my retirement, yes.
The amount may kindly be paid, that is 1 lakh. Fifth line.
Yes.
Your Lordship may kindly have a glance to page 147.
147.
147 and 148.
Yes.
As my learned friend submitted that, the grandfather submitted bank draft. The receipt may kindly be perused. What is the number of bank draft? I do not know. 148 and 149.
Yes.
Rupees 1 lakh. Your Lordship may kindly thereafter refer to page 150.
150.
151.
Yes.
The first paragraph.
Yes.
Paragraph 1.
Whereas
the vendor will sell the purchasers 0.067 acre of land appertaining to half plot number so and so for a total consideration of rupees 3 lakhs. This agreement was prior to the sale deed. Your Lordship may kindly have a glance.
But sale deed says that 81 lakh.
Received 1 lakh, agreement is 3 lakhs.
My lord, 81,000 after advance was taken during the execution of the agreement. The best amount was paid during the
this agreement which he's agreement 3 lakhs you said.
Sale deed
How it is 81,000?
Grandfather paid 1 lakh.
And you prepared a draft of 1 lakh rupees.
Agreement is 3 lakhs. Received payment was made 1 lakh. Sale deed is 81,000. Which one is?
All these things are doubtful, sir.
Will be trial. It will be debated. It will be decided.
consideration amount 81,000.
No visualize.
Jyoti, you have hard copy? So
This appellant is in no way prejudiced. Only to protect that they will not align it, or your Lordship, my learned friend read the portion of the improved order, left the last portion. The criminal miscase is allowed on contest against opposite party dated 24/6/2016. You are hereby made absolute. My humble submission before your Lordship is that on 24/6/2016, interim order was passed. In 2023 December, this appellant and his father filed objection. After 7 years, they have not challenged that due to
interim order is not.
interim order not challenged. And it is the opposite party.
I am
Hereby restrained from alienating, pledging, or transferring the.
that was the terms of the earlier interim order.
Yes.
Attachment order.
Yes. Only order in the land, not to align it.
That is the order passed under section 4 while presenting the application. When I was hard by the fire.
According to me, you don't have a case. What to do?
And I am even permitted to file relevant documents.
No, you have all the documents, more than enough. And more the document you file, more the doubt you create.
The document which you have filed, those documents are doubtful.
It is only attached. No seizure has been made so far as sale deed and land record is concerned. And I am paying, I have obtained a bank loan, I am paying EMI. I have been prejudiced because I want to some more amount for repair work of that building. Due to this attachment, I can post it on my own property.
Yes, I'll pass on. I'll pass. If you want to give in writing, you can. If
I have referred all these documents. Refer to
you don't want to file
I will file one page
written note with the relevant pages.
Yes.
You also file. Yes.
And reflected name may be reflected.
Yes.
In the
so much your name has to be there.
No, in the cause list it is not there.
But so far the order that is 16 is correction. That is the interim order passed during present of the application. In my absence, this is the absolute order. So there is no challenging that order. I don't understand.
You have a right to challenge it, but on facts, there are some reservation. Anyway, I'll pass the order. Yes.
Sir, 1 week time.
Okay. And exactly one file, any judgment if you want to rely that.
74.
Yes, sir.
The Certificate of Appeal. The fresh matter, they are convicted under section 409, 467, 471.
Sentence
Sentence was 4 years.
undergone,
Fine of rupees 55,000.
undergone. How much was undergone?
Custody since 18/9/2024, more than 1 month.
Yes, admit. Okay. Admit bail granted. Realization of the state. Called TCR, huh? Called
Yes,
TCR.
yes.
Okay, please.
Question by
Yes.
presence may be recorded.
Opposition of Mr. Naik. Recorded, huh? Okay. Yes, sir.
Custody since 16/10/2023, my lord.
Yes.
Earlier, I have approached this honorable court. Since charge sheet not filed, your lordship remitted back, move after submission of charge sheet.
Hmm.
In the meantime, charge sheet submitted, I have moved again and come before your lordship.
Hmm.
So far as the petitioner is concerned, my lord, as per statement of one Gopal Nahak, my lord,
You are in custody since?
custody 16/10/23.
Council appealing for the informant, my lord, is not present.
She had
I'm there. I'm there.
He's there, he's there. Mr. Mahapatra is ready to attack.
Yes. As per allegation, my lord, 212 allegation. After they have committed the act, my lord, they came
What are
and
the offenses?
offenses. my lord, 364 charge sheet submitted, my lord, 364, 201, 302, 120B, 212, 34 of the IPC and 25, 1A of the
Yes. Arms Act.
Arms Act, my lord.
Yes.
Here in this case, my lord, so far as 302 is concerned, he is not liable. He was not present, nothing he has done, my lord. As per statement of Gopal Nahak, my lord, I am read out the statement.
Hmm.
ଗତ 6/10/2023 ଦିନ ଦୀପୁ ପାତ୍ର କୋଦଳା କୋର୍ଟକୁ ଆସିଥିବା ସମୟରେ ନିଜ ଗ୍ରାମକୁ ଫେରିବା ବାଟରେ କୋଦଳା 7 ନଳ
Where are you reading?
statement of ମୁଁ ସେଟା
ଆସିନି ଗୋପାଳ ନାୟକଟା।
that is one statement I have given, my lord, your lordship.
This is for your consumption only, not for court. You read something, told you, have you filed it?
ନାଇଁ ସେଟା file
Read it, read.
Order yourself.
ମୁଁ ପଇସାରେ
What is the role attributed?
ଲର୍ଡ ମୋ ଭଣଜା ରାକେଶ ନାୟକ,
ରାଜେଶ ନାୟକ,
ରାକେଶ ନାୟକ,
ବାବୁଲା।
alias ବବୁଲ, ପିତା ମିଟିକି ନାୟକ, ଗ୍ରାମ ହରିଜନ ସାହି, କବିସୂର୍ଯ୍ୟ ନଗର, କବିସୂର୍ଯ୍ୟ ଥାନା କବିସୂର୍ଯ୍ୟ, ଜିଲ୍ଲା ଗଞ୍ଜାମ ଆସି ମୋ ଘର ହାଡି ସାହି କୋଦଳାରେ ରହୁଥିଲା। ସେଇ ସମୟରେ ଆସାମୀ ବବୁଲ ଗୌଡ ଓ ତାର ଏବଂ ଉତ୍ତମ ବିଶ୍ୱାଳ ଆଲିଆସ ଭୁକ୍ତଙ୍କୁ ସେମାନେ ଆସାମୀ ହୋଇଥିବା ଜାଣି ମୋ ଭଣଜା ଆମ ଘରେ ଆଣି ତାଙ୍କୁ ଆଶ୍ରୟ ଦେଇଥିଲା। That is the allegation. 212 charge sheet submitted, so far as the petitioner is concerned.
That happened, my lord. Other materials, my lord. Here, my lord, the police recovered all the weapon offences, my lord, from his house, my lord.
Yes, this
From the house. All the swords and the gun, everything, my lord, recovered from his house, my lord. Though 212 is there, my lord, investigating, harboring the offenders, my lord. And that happened, my lord, the eyewitnesses, though not named the petitioner, my lord. I read out one eyewitness statement, my lord. Relevant person.
ମୋ ନା କେହି ଆଜ୍ଞା
ମୁଁ ସେଟା କହୁଛି ଥାନା ତ ସେଠାରେ ସେ ଦେଖିଲା ଯାଉଥିଲେ ସେ କୋର୍ଟକୁ ଆସିଥିଲା ଦିନ ଘଣ୍ଟା 12:45 ଗୋଟେ ସମୟ ମଧ୍ୟ ନିଜ ଗ୍ରାମକୁ ଫେରିବା ବାଟରେ କୋଦଳା ଛକ କୋଦଳା ଥାନା ଅନ୍ତର୍ଗତ ଜଗନ୍ନାଥପୁର ଛାନିର ସନ୍ୟା ସେଠୀ ମେନ୍ ଆକ୍ଟିଂ ପର୍ସନ ସନ୍ୟା ସେଠୀ, ହୀନ ସେଠୀ, ସଙ୍ଗୀ ପରିଡ଼ା, ଚନ୍ଦନ ସେଠୀ, ଚନ୍ଦନ ରାଉତ, ଲିପୁ ନାହକ, ବାବୁ ରାକେଶ ପରିଡ଼ା, ଆଲୋକ ପ୍ରଧାନ, ସଞ୍ଜୟ ରାଉତ, ଲିଟୁ ନାହକ, ବାବୁନି ଗୌଡ, ଭୂତ ଉତ୍ତମ ବିଶ୍ୱାଳ, ଅନ୍ୟମାନେ ନଟ୍ ସ୍ପେସିଫିକ ନେମ୍ରେ ଦୀପୁକୁ ଅଟକାଇ ମୋ ମୋବାଇଲ ବନ୍ଦ କରିଦେଲେ ଓ କଲର ଧରି ମତେ ବାଡେଇବାରୁ ମୁଁ ପ୍ରାଣ ବିକଳ ସେଠାରୁ ପଳେଇବାକୁ ସକ୍ଷମ ହେଲି। ସମସ୍ତେ ବାଇକ ଯୋଗେ ସନାତନ ଖଳ ପଡିଆକୁ ନେଇଗଲେ। ଚନ୍ଦନ ରାଉତ ସ୍କୁଟି ଯୋଗେ ଦୀପୁ ପାତ୍ରକୁ ଦୀପୁ ପାତ୍ର ରିସିଜ ସନ୍ୟା ସେଠୀ, ଚନ୍ଦନ ସେଠୀ ତାକୁ ମଝି ବେଳେ ବସାଇ ସାନ୍ତଳା ଖେଳ ପଡିଆକୁ ନେଇଗଲେ। ତାପରେ ମୁଁ ପ୍ରାଣ ବିକଳରେ ମୁଁ ମୋ ଘରକୁ ଫେରି ଆସିଲି। ତାପରେ ତାଙ୍କ ଘରକୁ ଜଣାଇଲି। ମୁଁ ଆଜି ନିଶ୍ଚିନ୍ତ ହେଲି ଯେ ମୋ ସାଙ୍ଗ ଦୀପୁ ପାତ୍ରକୁ ମାରିଦେବା ଉଦ୍ଦେଶ୍ୟରେ ଅପହରଣ କରି ସନାତନ ଖେଳ ପଡିଆରେ ମାଡ ମାରି ପୋଖରୀ ପାଖରେ ବୁଢା ଭିତରେ ଲୁଚାଇ ରଖିଥିଲେ। That is matter. He has stated that these are the accused persons with the others manner, अन्य manner. But in fact, manner he has harbored the accused and all the weapon offense seized from his.
They harbor the weapon of offense.
That is matter. And so far as the co-accused person is concerned, manner.
What are the antecedents you tell me?
No, but in fact, my lord, while disposing the bail application of the co-accused person, my lord, your lordship given liberty to renew their prayer after 6 months of this.
ସେଇଟା ଆଜ୍ଞା ମେନ୍ ଆକ୍ୟୁଜ କର ମୋର ହାର୍ବରିଂ
Sanjay Rao.
So they are in the eyewitness statement.
Sanjay Rao's name is there.
Yes.
In eyewitness.
Yes.
That's the distinction.
Yes,
Yes, Mr. Mahapatra. What do you say?
My lord, when all the offences, alleged offences of the crime has been seized from the possession of the petitioner, it itself establishes that he is the main person behind the crime. 161 statement somebody has not said. It is to be proved in course of the trial.
There are eyewitnesses those who have not taken his name.
So let those eyewitnesses be examined. After he may renew his prayer after those witnesses is examined.
No. See, what are the favorable circumstances looming large in the record is, first of all, he is in custody since about a year.
Yes, sir.
Second is the eyewitnesses have not taken his name.
No,
Third is the order which I passed, saying that the eyewitnesses to be examined after 6 months they can renew the bail plea. This is regarding one Sanjay Rao whose name is taken by the eyewitness.
Yes. Also withdrawn, my lord.
None of the eyewitness is taken the name of. Then
another thing, my lord.
He doesn't have antecedents also.
And here the
no antecedent.
Yes.
was a person who was a witness in the criminal case. He had been to court for giving a deposition. After coming back after giving deposition, he was kidnapped and murdered. This is the circumstance. I do admit that I cannot improve the case when the materials 161 statement does not show. I cannot say that there is there. But only thing the investigating report which is relied upon by the prosecution that all the weapon of offences.
How many eyewitnesses are there?
There are 2 eyewitnesses, my lord. They are, my lord. But circumstantial evidence against other co-accused they are, my lord. Last in theory, others they are, my lord. Some material persons against the co-accused persons, my lord.
But what about this man I am talking about?
This the evidence, my lord. And another thing, my lord, while the I was submitting charge sheet against the other accused persons, my lord, submitted charge sheet under 364, 302, 201, 120B, 34 is reduced section 25(1) of Arms Act. But with regards to specific this petition, my lord, charge sheet under 364, 302, 201, 120B, 212, 34 IPC, and 25 of Arms Act.
What is left? What is left?
Madam? Extra another adhesion. Including that offense, madam.
ସେଇଟା ତ କରିବ
120B ଅଛି.
And including that offense is the 112.
What do you say? You file the affidavit that you don't have any.
He has stated, my lord, state council stated.
You have to file affidavit. You can see.
Your lordship indicate subject to verification of antecedent. That order may be passed.
Yes, Mr. Mahapatra, I am granting the. Because eyewitnesses have not said anything. Okay, right on. Petitioner is accused and so on, so on. Allegation against the petitioner and so on. 2 eyewitnesses, namely.
Shambhu Kuntia,
Satyapatra, and Rudrapatra.
Satyapatra and Rudrapatra. In their statement given to the police under 161 CRPC have taken the name of the co-accused person.
These would have seen the first part of occurrence when they are kidnapped.
They have taken the name of the co-accused persons. However, insofar as the present petitioner is concerned, both the witnesses have not ascribed any specific role to this petition.
So they named some of the co-accused persons, but stated that others also.
And that I'll record. And Mr. Raghuda, learned counsel for the state, and Mr. Diptiranjan Mahapatra for the complaint has been heard extensively. Mr. Raghuda points out that although the witnesses have not taken this name of the present petition specifically, but they have both the witnesses have said that the accused persons, named accused person, and other individuals were accompanying the main accused persons. From the position of the present petitioner, all the offense of weapon of offense has been recovered, and it is a specific allegation made in the charge sheet insofar as the present petition is concerned regarding harboring the co-accused persons. Therefore, apart from the other offences, therefore the charge sheet has been filed against the present petitioner, including the offence under section 212.
On Gopal Naik, he stated about the harboring the
212. Mr. Mahapatra, Mr. Raghuda also read out the statement of one Gopal Nahako, who has very specifically mentioned alleges against the petitioner, the present petitioner, that
some of the
petitioners has harbored some of the co-accused persons. How many accused are there?
More than 16, my lord.
In the present case, there are more than 16.
More than
16.
My charge sheet submitted twice, my lord, and also the investigation keeping open, my lord.
More than 16 accused are there. The investigation is still kept open.
Sorry. 17. Final charge sheet submitted, my lord. 17.
Investigation is not. Investigation has already been completed. The petitioner is in custody from 16/10/2023. Since the witnesses have not taken the name of the present petitioner insofar as the prime offence is concerned, and the only allegation against the petitioner appears to be regarding the harboring of the co-accused persons, and recovery of weapon of offence has been effected from him. I find the case of the present petitioner distinguishable from the case of other co-accused person. At this stage, Mr. Mahapatra, learned counsel for the complainant, has pointed out that one Sanjay Raut had co-accused Sanjay Raut applied for bail before this court, which was turned down by this court by the order dated 2024, and that accused was granted liberty to renew the bail plea after the eyewitnesses are examined or after the expiry of 6 months. The role of the said co-accused person Sanjay Raut is also distinguishable because the eyewitnesses have taken the name of the said witnesses. Eyewitnesses have taken the name of the said co-accused person. Regard being had to the fact that the petitioner is already in custody for more than a year, and charge sheet has already been filed. the fact that the petitioner's name has not been taken by the eyewitnesses, I'm inclined to enlarge the petitioner on bail with the condition that the petitioner shall appear before the IO on every Sunday. For from 10 o'clock to 12 o'clock for 6 months, and subject to verification of the antecedents.
Similar antecedents. Okay.
Yes.
76. Matters. The petitioner inside custody from 24/6/23 matters. 24/6/23 matters.
23.
Yes, ma'am.
Yes.
The matters earlier matters disposed of by saying that you come after charge them and the only eyewitness after the examination of the only eyewitness. He has matters I have to examine. No. He has hotel and annexed 3 minus page 14.
Where is the order? The order which?
Minus?
The earlier order?
That is the dispose of case minus.
Where is that order?
That is minus.
Where is that order?
I know earlier order minus, but that has been passed by minus.
I need to know that order.
That is after charge. Minus said that after charge.
I don't know what I said. Unless that is place of the court, how will I connect it? After next week. You find it. Let me understand what term I am rejecting. Let me understand that. Yes.
77.
Yes.
Make easy lordships. The second round litigation lordships. Lordship was pleased to release the petition on bail while annexed to by order dated 10/9/2024.
Yes.
At that time, it was found from record that he had no criminal antecedents. The state council also said that they know. But when your lordship was directed for verification of criminal antecedents were found, and that is your lordship will find the report at the very at page 22.
Yes.
Your lordship started with before vacation. Your lordship had directed the learned counsel for the state to verify whether there are any antecedents or not. They are.
Subject to verification.
Lordships.
And while verifying, to understand,
were found.
But I have got to instance.
I'm passing.
What is the offense?
420.
420.
Reliance this 420. There, in that case, as it's submitted, and another case he has been acquitted. That's it, relying that.
I granted the bail.
Lordships. Your lordship will find the order at page 16.
16. Okay.
Lordships.
Where is that condition?
Your lordship will find it at page 18. The very first paragraph starts at hence.
Okay. Right. By the order dated. This is the modification application. What?
No,
what? Yes. Rejected. Okay. By the order dated 10/9/2024, this court allowed BLAPL number 5445 of 2024, enlarging the petitioner on bail on the condition, on various conditions, including the condition, including the various condition. One of the subject to verification. The petitioner was enlarged on bail, subject to the verification of a similar type of antecedent to be ascertained by the trial court. Pursuant to the said order, petitioner applied for his release before the court below. The court below, by the impugn order dated
13/9/2024,
refused to release the petitioner on the ground that it was discovered that he is involved in two more cases. Notice was issued by this court on 7/10/2024 for verification regarding the antecedents. Persons thereto, Mr. Ragda has placed on record the instruction dated 17/10/2024 given by the IIC Titlagarh, District Bolangir. As per the instruction, the petitioner has two criminal incidents. In one of the criminal case registered against him, he has already been acquitted by the trial court, wherein the other criminal case, petitioner has already been charge sheeted and on bail and has already been enlarged on bail. Taking into consideration the aforementioned instruction, I am of the considered view that the petitioner is entitled to the benefit of concession of bail already granted to him by order dated 10/9/2024. Accordingly, the present petition is allowed. The petitioner is enlarged on bail on the condition to deem fit and proper premises.
Another case for appearance,
Appearance and seated and on bail.
I may be pardon, Millards. I missed item, Millard. Item 78. It is for filing of certified copy. Your Lordship may kindly take up it on next Tuesday, Millard, on 29. I will be filing the certified copy of the impeached order.
Oh, do you have certified copy?
No, I don't have.
If you have, you can give it.
No, I don't have. So it may be taken up on 29th, Millard, and your Lordship can dispose it of.
I may be pardoned. Dispose it of means you don't have.
I don't have a good case, but
then easy to dismiss.
And maybe pardon. I may be pardoned. Item 85 and 86, I was intimated that the vigilance level has taken time in this. That there is an interim order, the court is issuing notices. Interim orders to be continued.
See,
85 and 86.
85. I was a bit reluctant to give adjournment because it is 2016 case.
But I have I have been intimated that it has been adjournment has been given.
86. Another honorable coordinate bench has passed in another case of this appellant, this petitioner, had filed against discharge. So that was being dealt with by my learned to associate Mr. Maharana. So let a present status from the London.
Next week I am putting it next week. Let us see.
Let a status report be present status.
Now, let me understand why to burden the trial court calling for everything you are not sure about.
In order to continue.
I have just entry order to continue. Put it next week. What matters?
1 week after let it come. I will.
After 1 week you get it.
I will get it.
2 weeks further. 2 weeks. 2 weeks.
I will getting it instruction from the government specialty.
And particulars of the other case which is pending.
Other case.
Yes.
Coordinate bench has passed some order.
Yes.
With conditions.
You get those things and after 2 weeks.
obviously.
Item number 81.
81.
This is a compromise. Compromise was there. Your Lordship directed both the parties to appear. Either on VCL, he could not come from Tamil Nadu, so he could not appear. Your Lordship was fixing month of November any day, he will come and appear.
No more. Yes.
But 11th week.
Okay, no more.
18th.
And Mr. Bose, and counsel for the petitioner submits that the parties have already settled the dispute. However, for certain difficulty, they could not appear in the court today, either through VC or in person. Therefore, he seeks accommodation. He leaves the matter on 8th. In 8th, 7th or 8th?
Yes, 7th or 8th. Item 82, and the petitioner is seriously in SCB hospital suffering from cancer at the critical stage. Now, she is the contesting candidate. Now, I pray from get some instruction what is the present status of the case, and there was an order of this court to obtain the status of the case to the state government law. So let it come after 2 weeks.
Why 2 weeks? 2016 matter.
No, that is the condition. She is in a critical stage at cancer in SCB, already admitted. So I obtain what is the condition? And that is stay order of this Hon'Ble court also. And notice has been issued in spite of the repeated notice. OP number 2 contesting but not appearing. That is the finding of.
What are the offences?
Offences in a 1cc case, cognizance has been taken against the wife, her sisters, her widow mother, her brother-in-law, everybody.
Cognizance under what provision?
Cognizance 202, 2294, and other sections, Annexure 1.
Okay.
That has been stayed by this Hon'Ble court. Notice was issued. Now the contesting husband did not appear.
this court, whether I'll put it after 1 week or 2 weeks?
Or 2 weeks.
2 weeks. 2 weeks. Yes, sir.
Senior my lord waiting in the item
Yes.
number 89, my lord.
Huh.
That's case, there is required, my lord.
89? Case diary.
Case there is required, my lord.
A call for case diary, then I'll put it after 1 week. Interim order to cut. Call for 89, call for case diary. Entry mode to continue. 89. Yes. Sir का appearance लगा देना. Appearance लगा. Yes. Thank you.
Mentioned. Item number 54. Petition permitted to withdraw the case that the matter has been increased settled and they have got approval from the loan portfolio.
Okay. That's the best thing for 54 is one can expect. First of all, you are withdrawing, secondly, you got acquitted. Both the things are happy to know. Yes, 54. Yes, next.
52, my lord.
52.
I pray for 2 weeks, 2 days time. Because, my lord, now after going through the order dated 11/23, I ascertained that some of the accused who have been entering the 107, they filed the personal bond, some have not filed. So I have to instruction whether they have, if they filed the personal bond, nothing remains. So,
Yes.
but lots of the order reveals that some have not filed the bond. So,
Day after tomorrow? Day after tomorrow. Yes. Yeah. And better you advise today that let them file the bond and come. Yes.
37.
37. Yes. What is this, Mr. Oda? 37? Cognizance order, 21. Non-APS.
Private.
What are the offenses? There is nothing. FIR and cognizance order, nothing is filed. Non-APS also. Right. Non-APS on behalf of the petitioner, even in the second call. Next paragraph. I have perused the in order, whereby the cognizance of offences under section 286/34 IPC, read with section 3, 5, and 6 of ES Act has been taken against the petitioner. There is a perusal of the ground on the basis of which the petitioner is seeking quashing of the cognizance order is devoid of merit, and therefore no interference is called for in the present matter. Hence, the petition is dismissed. Yes.
42.
And however liberty is granted to the petitioner to raise all the point at the appropriate stage before the trial court. Yes. 42. What is this matter?
Personal matter, my lord, 20B to C. And defense, my lord. Petitioner is the owner of a vehicle.
Seeking for quashing of the entire proceeding.
My lord.
The petitioner is accused in FIR number so and so for alleged offence under section so and so. It is non-APS for the petitioner even in this phone call. I have perused the documents placed before this court and analyzed the placed before this court. Perusal of the FIR and charge sheet reveals that the petitioner is the owner of the vehicle. Owner of the vehicle in which the contraband articles were being transported, sought to be transported. Petitioner is seeking quashing of the entire criminal prosecution initiated against him. I am not inclined to.
I'm sorry, Bishop.
Which one?
Item 42.
There is nothing. I was about to. Yes. What do you say?
Only limited prior before lordship, usual order. I am protected. I will surrender before the court below and move for bail.
Because earlier you were surrender and
when is that order? I will reinforce that order once again. So give me that order.
No, print out of
Give me that order so that I'll say that I withdraw to avail the benefit of the order dated so and so passed by the coordinate bench. Finish. Where is that order? This.
Yes,
Mr. Das, Legal Counsel, would cut the Das, Legal Counsel for the petitioner seeks to withdraw the present petition in order to avail the benefit of the order dated 2/11/2023 passed by the coordinate bench in ABPL number 11592 of 2023. I have perused the order dated 2/11/2023 passed by the coordinate bench, whereby the petitioner was granted liberty to surrender before the court below within a week from the receipt of the certified copy of the order and to move for bail, which shall be considered on merit. It appears the petitioner has not availed the order of availed the benefit of the state order. Hence, the present petition is disposed of with a liberty to the petitioner to surrender or appear before the court below within 15 days.
Within 3 weeks,
within 3 weeks, and availed remedy under law with this subject petition.
Till that date, I may protect. Till that date, I may protect them.
This order was passed when 23. Actually, nothing happened. And you were self-protected. You were self-protected. This order is 2/11/23, 1 year. Self-protected. Why you seeking that kind of protection?
Sympathy that much, my lord. Limited prior before.
No, that I can't do it because in the face of that order, I can't undermine the order of a coordinate bench. That's the problem. Otherwise, you would have done it. Otherwise, you would have done it. It's not fair. Yes.
Item 50.
50? Yes. What is this matter?
Are supplied the collector of the tariff will move there, they restraining. The collection of power tariff was made at the time villagers, these persons are restraining and misbehaving.
So he is seeking quashing.
Yes. FIR
FIRs are there.
FIR quashing.
FIR is there? Non-appears for the petitioner even after second call. Second call, huh? Petitioner is seeking quashing of the FIR PS Bill Maharajpur, right? Maharajpur PS case number 254 of 23, corresponding to GR case number 655 of 2023. Except to the copy of FIR, no other document has been filed. Even none has appeared to assess the court. In view thereof, the petition is dismissed for non-prosecution. Yes.
63.
Dismissed for non-prosecution. Nothing is filed except FIR.
63 permitted to withdraw my.
Withdraw. Okay. Submitted to. Yes.
66.
Don't you need any liberty?
Because it has already.
Okay. 63. Yes.
66.
66.
Quashing of cognizance matter 376 and POXO are there.
POXO 76, eh?
Right.
Now, cognizance order, huh?
Cognizance order.
Even in the second call non-appear for the petitioner. In the present petition, petitioner is seeking quashing of order dated 15/7/2017, passed by the which court? Passed by learned ADG from special POXO Jajpur, whereby cognizance for offences punishable, cognizance of offences punishable under section 363/366/376 I IPC, read with section 6 of POXO has been taken. Since the next paragraph, since the cognizance was the MP note was passed way back in 2017, and the present petition has been filed belatedly. Apart from the fact that there is nothing, there is no case on merits. No case of merit. I'm not inclined to give indulgence to the petitioner at this belated stage. Accordingly, it is dismissed. Yes.
79.
79, criminal appeal. Yes.
79, Mr. Maharana requested me that he will seek.
Okay. 2018.
No, I am ready. Mr. Maharana has some difficulty.
He's asking for Monday.
Not Monday, not possible. Put it up to 2 weeks.
Mr. Maharana said that on 4th at 2 p.m. it will appeal for hearing.
Appeal for hearing, no? 2018 matter. Let it be on weekly. What is the weekly? I am taking seriously.
I am.
Weekly, rako. Serial, na? Serial, yes.
Item 80.
80, I am for the opposite party.
Yes, sir.
On behalf of Mr. Maharana, I am to submit.
Yes.
This revision of disposal of directing the petitioner to make payment of rupees 1,20,000.
Copy may be solved.
Yes.
Rate for extension to carry out your lordship's order, because in the meantime his mother was seriously ill.
Which order you
The lordship had disposed of right order 23/7/2020. That I will deposit the fine, the check amount within a period of 2 months.
Subject to the petition making good the remaining compensation amount of 1,20,000 within a period of 2 months from today. He's asking for
only for the extension.
I have no objection. I only supply the copy.
Change the copy privately. Right? This is an application of modification
for extension.
The IA number.
Well, IA number is 972.
972.
IA
number 972/24. By way of this application, petitioner is seeking extension of time for compliance of the order dated. The terms of the order dated 23/7/2024. For the next for the reasons stated in the application, and the same is allowed. 2 months time. 2 months, sir? 2 months. How much you are asking for? 4 weeks. 4 weeks time. as read in the application for compliance of order dated 23/7/2004 is allowed. It is made clear that no further extension shall be granted on any ground whatsoever. Yes.
Great. Okay.
Copy, you take a copy. Yes. Give the copy for obvious reasons.
I'll just share him a soft copy.
Yes.
There is no problem.
Okay. Thank you.
I know this.
Yes.
83.
The petitioners and the appeal number 4 they belong to one family. And the petition number 4 is and the appeal number 2 their husband and wife.
What are you asking?
Questioning the proceeding on the ground of compromise between the parties. Let's not turn it on to the annexation with the last annexure. That is page 25.
Yes.
Both the petitioner, petition number 4 and appeal number 2, they have decided to stay jointly, and according to the petition filed by the petitioner that on 16/1/15 on the special matter that was drop in the ground that both the petition number 4 and the appeal number 2 they are staying jointly, madam.
Jointly?
Yes, madam.
And FIR is for 498A.
FIR number for 294, 506 and 340.
Then why can't you make them appear?
The matter 2016, I don't have any connection with them because the lower court council they asked me.
No, 2016 they were staying separate.
Yes, madam. Yes,
but now are they continuing?
Yes, madam. Blood offenses were 294, 506 and 341.
341.
Yes, madam.
And then you say that relying upon this annexure 5 you call it.
Yes, madam.
What do you say?
That's but regarding the petition of the information. A petition has been submitted and it has also been mentioned in the
Affidavit, where is the affidavit?
Affidavit.
In this case, you have not filed affidavit.
No, not filed.
That's the problem. In this case, at least you want me to rely upon the proceeding of 2016. I don't know what is the change today.
But annexure 5 page 25.
You're right, I understand it.
Yes, madam.
only that.
But that those things are 2016. Now I don't know whether
And also can go to the page 23 annexure 4 that Vikram between the petition number 4 and the appeal number 2 million. You notice how
all these things are 2016, sir.
Yes, madam.
Then shall I put it tomorrow? You will ask seek instruction and tell the informant to appear online. If they are staying together, what is the big deal about it?
The Monday at least, but I don't have a
Monday. Okay, Monday. Let her appear so that it is safer,
Yes,
2016 some affidavit given in some other proceeding. Relying upon that
in special matter,
whatever is not in this proceeding.
Yes, madam.
Some other proceeding. Had it been related to this proceeding, I will have Monday.
Yes,
Monday evening. Online, don't bring them here. Online. Yes.
84.
And ask for an Aadhaar card so that you place it on. Yes.
84 yellow if I play for next week.
Yes.
I play for next week.
What is this matter, sir?
Taking passing of complaint case, filed by opposite part number 2. Or your lordship is tomorrow, your lordship.
No. Is there anything? 2016 matter.
My lord.
Is there anything survives?
Yes, your lordship.
Because there is no stay.
May be taken up tomorrow, your lordship.
What is it? 2016? What happened?
That fell. Your lordship.
So then on the basis of compromise, you sought quashing. And it was referred to mediation. Mediation failed. The compromise goes. Compromise goes. Then where is the question of quashing?
Whatever he says is appears to be possible defense. There is nothing, my lord.
Tomorrow, your lordship.
Put it next week. Next week. Learn concept for the petitioner seeks an accommodation for today. in the interest of justice, leaves the matter on Sunday. It made clear it's that no further adjournment shall be maintained.
I am there, my lord, for the opposite party.
Interim order is there, therefore it is pending since 2016.
No, the lordship will also find that his whatever he said is only his possible defense.
Maybe this given this case pilot is directed against the order taking cognizance passed by the SDGM Kionjar, taking cognizance of the offences punishable under section 120B, 468, 471 by 34 of the Indian Penal Code matter.
Yes.
It is as per the allegations made in the first information report, but I kindly see the first information report.
Yes.
Well, that is at page 12.
You are Basant Kumar Behra.
Basant Kumar Behra.
Yes.
Page 11, page 10, my lord.
Yes.
So, informant is the manager of the bank. It is alleged, senior branch manager of Syndicate Bank. It is alleged that bank had sanctioned loan, 11 numbers of loan for tractors loan to various borrowers. But before sanctioning of the loan, documents were sent to the present petitioner, who is a practicing lawyer of Kionjar Bar. That is there in the affair. Basant Kumar Behra, advocate, and to give his legal opinion. As per the documents, he had given his legal opinions. And ultimately, it was found the documents had, some documents were false documents, which were submitted by the bank to the lawyer. So, basing upon the documents, he has given his opinion. And accordingly, FIR was lodged against 13 persons, but petitioner was not there as an accused. He has been charge sheeted, and accordingly, cognizance has been taken against him. So, my humble submission before my lord is, as a lawyer, he has done his professional duty. Whether it can be conceived
in an unprofessional manner.
So in a professional manner. They say, I have conspired with the borrowers while granting loan, but they have not shown a single document. Well, a criminal conspiracy, it is very easy to make allegations of conspiracy in any case. But law is very clear in that respect, and I'm
under the head of 120B, you have been routing.
Yes, madam. Madam, may kindly see, I have
See, banking party or lordship, at least banks into
yes, of 2016, if you want to drag it around, lawyer will not.
but actual bank is doing
the
now, the question will be there without the
because the party, why bank will be?
Bank is informant, yes.
Madam, may kindly see the first judgment. This is the fact. So I'm just drawing my attention to some Supreme Court judgments, including some judgments of our High Court in the same case everywhere advocate. The first judgment is CBI versus K. Narayan Rao. Pilot C, para 27.
27.
Mallet. Case 22.
22, right.
Why are you giving copy to my radio? Answer. List.
Yes, sir.
In the banking sector, in particular, rendering of legal opinion for granting of loans has become an important component of an advocate work. In the law of negligence, professionals such as lawyers, doctors, architects, and others are included in the category of persons professing some special skills. A lawyer does not tell his client that he shall win the case in all circumstances. Likewise, a physician would not assure the patient for full recovery in every case. A surgeon cannot and does not guarantee that the result of surgery would invariably be beneficial, much less to the extent of 100% for the persons operated on. The only assurance which such professionals can give or can be given by implication is that he is possessed with requisite skill in that branch of profession which he is practicing, and while undertaking the performance of the task,
entrusted to him.
Ready, next one.
My lord, next is my lord, the implied upon.
Anu Srivastava.
Yes, my lord. Next judgment. That is also paragraph 26 and 27.
Yes. 26
and 27. That is at page 34. That is with regards to conspiracy, my lord.
26, 27. All everywhere they are lawyers.
Everywhere lawyers.
These people are lawyers.
Yes.
Yes.
Yes. My lord, most important, my lord, all the judgments have been taken note of by our High Court. My lord, my kindly see two judgments I am trying. My lord, attention, my lord. My lord, that is by page 41, by Honorable Justice Das, my lord. Here, Nusrigan of Mishra, he was also a senior lawyer, a CBI case was there.
Which paragraph?
Paragraph 4.
Yes.
And let me just underline that and add.
Yes.
Paragraph 4.
In instant case.
But in instant case, let me say around 8-10 lines. At this juncture, it would be profitable to note.
Yes.
I got it? At this juncture, it would be profitable to note that the other accused is an advocate who was engaged by the New India Assurance Company Limited to investigate the case, and while performing such professional work, he sent a report that he could not trace out any records regarding the hospitalization of the petitioner at SCB Medical College Hospital. There is no material whatsoever to show prima facie that the co-accused, in order to cause an illegal gain to either himself or the petitioner, or to cause illegal loss to the company, gave such a report.
And the insurance report case.
My lord, again, my lord, insurance. My lord, a report or opinion rendered by an advocate to his client, if found to be incorrect, cannot constitute an offense where nothing is shown that such report or opinion is purposefully given to commit any offense. The prosecution has also not.
There is a vital difference between giving a report and opinion and verification of a document.
Well, she has given a report.
I'll tell you why I am telling you this. If you give an opinion or a report, it is based on your judgment. Judgment of a individual may be wrong, but you assess document on the basis of which you are given an opinion. It may be wrong, right?
Yes.
So on that basis you can't prosecute. But if a task is given to you to verify the authenticity of a document,
yes,
being a lawyer, you verify the document and say this document is correct.
No, I have to.
Then you can prosecute.
Here by as a patent lawyer of the bank, they say I was chosen by the manager without
opinion was not sought. No, not so. Verification of document sought to be done only for that purpose. We are examining a proposition of law.
They say Mr. Behra was not a patent lawyer. He was chosen by the authorities to give opinion in that respect. He thought this opinion.
Opinion is error of judgment.
Yes.
For that you can't prosecute.
Yes.
That's the
and they say he was not the patent lawyer of the bank. So I was not forced myself. They give this document to me, I will give opinion. I was appointed by your authorities. But let me complete balance, then I will answer to his queries. A report or opinion rendered by an advocate to his client, if found to be incorrect, cannot constitute an offense where nothing is shown that such report or opinion is purposefully given to commit any offense. The prosecution has also not come out with any material disclosing meeting of mind between the two accused persons to bring home the charge. Let them show, yes, I was discussing with A for his report. Charge under section 120 IPC, rather the allegation in the affair was made that the co-accused conspired with one Benu Madhav Diveli, who was functioning as a divisional manager, so and so. Well, may see at this juncture, paragraph 7. He has taken, this Honorable Court has taken note of all the other decisions in the paragraph 6. Paragraph 7, in the instant case accepting the entire materials produced by the prosecution, along with the charge sheet in its entirety, no offense is made out against the petitioner as well as the co-accused, allowing the case to continue amount to a funds. By the next judgment by our High Court also, paragraph 7, 8, 9, and 10. That is at page
Rather, the last judgment of Justice Savitri.
My lord, that is also very clear.
Very clear that will help you. That part is.
I'm coming to that. I'm coming to.
I read all this. I read.
My lord,
Yes.
then you practice. Long practice.
I read it. That's the only judgment which will support you.
My lord.
How will you answer Justice Ratho's judgment?
No, I have not got that judgment.
Read any other judgment, read that judgment. If you come over the judgment,
I will
then directly. If you don't come over, he directly covered with.
Actually, bank is the opposite party.
You are the prosecutor. Forget about the bank.
Bank has.
You are the prosecutor, you have to justify. You are prosecuting someone. I will read that judgment and tell me whether you can overcome that judgment. All other judgment, he is not covered. He is covered by the last judgment. You are practicing lawyer, verified the document and suggested, and on the basis of which the bank has accepted the collateral.
All the earlier judgment which I referred, that has also been taken note of.
But that's opinion cases. Opinion and this case is different. Here, document verified, that was accepted as a collateral. The property was accepted as a collateral. And this court says that even after verification, the lawyer is not responsible. How will you get over? Directly court.
And he is also lawyer of effect. This Sankar Mishra is lawyer.
I reserve the judgment. You report it, answer it.
No, I'm not saying the judgment.
You take it directly confidential. What to do? You want your time tomorrow?
Yes.
Tomorrow. Give a copy tomorrow. Tomorrow. Only get over that judgment. Yes. Otherwise, that is very clear. Tomorrow, sir. Tomorrow. Yes.
Yes.
88.
As a partner matter, so that it can be.
Tomorrow. Day after, let it be day after.
Yep.
At least he may not. Take the copy, otherwise you will ask examination. The instructing counsel has to take it. Yes.
88.
May I please?
Yes.
Here, this is a complaint case, my lord. Yes. You can take cognizance order I have done. This was almost, my lord, over, my lord. I have submitted all the memo of citations, date chart, everything. Only because the opposite party did not appear, the counsel, that was urgent.
Who is opposite party?
The opposite party, my lord, one Disturb Darai was appearing. Last year, see the last order.
Yes.
Yes.
Yes. Okay, just forget. You satisfied.
Here is a case, my lord. Yes, here is a case, my lord, and the petitioners, my lord, before your lordship, are the employees of the Tata Interactive System Service, my lord. System, my lord. Yes. The respondent, the opposite party number 2 is the director of one, my lord, Millennium Academy Higher Education at Nayagad and, my lord, another place, Khanpada, my lord. Yes. They have the service of the petitioners for introducing the Tata class.
Come to your date chart. Let us see this. Very short one. Just run through this. Just run through. 25 to 2013.
Yes.
Yes.
The agreement, they entered into an agreement, my lord. The agreement was, my lord, the agreement I had, my lord, annexed. The agreement is at page 3. Okay. Page 38.
The complainant requested the academy manager to hold.
And the schedule of payment and everything at page 48 and 49, my lord.
Outstanding due.
The schedule of payment they are supposed to give, my lord. Thereafter, my lord.
Both the checks. Sanjeev Kumar, sir.
Then, my lord, they requested, the complaint requested the company under Annexure 5.
Yes.
My lord, we sent a demand notice under Annexure 4 at page 50. That you did not pay the balance of the installment dues, you please pay. They responded at page 51 that please cancel the agreement. The financial year estimate come to page 52.
Also, the page 52. Please read through. Let me understand that. Catch the facts first. When the complainant avoided making the payment of the company after purchasing the losses breakage from the company. Page 50, I'm there. Demand notice. I'm reading. The agreement with your school is terminated. The hardware installed in the school have been repossessed by PIS. You are under the obligation to clear the outstanding bills of 1,60,000 against the invoices already generated. Please note that even in this event, your school does not clear the amount within 7 days of the receipt of this letter. The PIS will initiate legal proceeding, legal action against your school in appropriate court in Mumbai, as per the terms of the agreement, my lord. Then, my lord, at page 51, to lawyer Kaluchan Swine, they requested, my lord, they issued 2 checks, my lord. Thereafter, they requested for my lord, paragraph. I understood. You tell me now what is your ground, my lord. Now, my lord, they have also paid given 2 checks that the suit were pending and all these things. Yes, suit pending. Yes. Now they come up with a false case that one of the director of the company, that is the person number 1, who has never come to, has visited Orissa ever, and the person of 2 have threatened them to blasphemous, the last person of the complaint person. What is the allegations, my lord? Yes. Yes. आपको कुछ नहीं. हाँ सर. Yes. Yes. My lord, the allegations here, paragraph, my lord, page 34. Page 34, paragraph 14, my lord. That again on 26/4/2015 at 9 AM, the accused person, namely 2 and 3, rushed to the office of the complainant at Noyagar, which is a residence house of the attached to the office of the office, and forcibly demanded him the amount. But when the complainant objected to the same accused person assaulted him and tried to forcibly kidnap him for murder. But when the witnesses reached at the spot and intervened, the accused person fled away. This is the only allegations, my lord. And you also may first, my lord, who is the, my lord, Western, the accused number 3. You'll also see accused number 3 is one. Yes. One Sanjeev Kumar Shaw, my lord. He has been, the allegation made in the year that I have the Sanjeev Kumar Shaw visited on 26/4/2015, but in fact he has been terminated from the service. Now I have given that annexure. The termination order I have also annexed here, my lord. He might have been terminating from service and going to his place and threatening. Also, from Bombay, he will come to just. I don't know whether he is coming or not. How do I know whether he came from Bombay or not? And cognizance says, how will I know that? But here is a case, my lord, it's a case of a civil nature, and just to avoid the payment of money, those things are there. But how will you get over these allegations for 13 and 14? 13 and 14, I have filed some documents, my lord. So, first, my lord, page 73, I have filed the document that he has been terminated since long, my lord. Page 73, you will also had a kindly page 73, my lord. You show me the cognizance order now. No, that's it. Cognizance order. What? Cognizance under, yes, cognizance order. Yes, I have seen. 2506 and 34. Certificate by page 36. 420 is not made out, 506 and 34 is made out. I have then come to 202 statements. Statement, my lord, I have not. That is the only test. In a cognizance order arising out of ICC case, I'll get this. What is the allegation? What is 202 statement? These are the two things I need to say. See, nothing more of that. All these documents which you filed are your what you call the defense. At this stage, I can't rely upon the document which is not part of the record at all to decide. And you can argue at the stage of charge.
This is a complaint case.
You can reach all this point at the relevant time.
Now, you will also imagine the persons from Bombay have to come to that. No, but trial, they have to come. That observation, I know you will also see all the director, one of them is director.
Maybe director, maybe whatever.
But if this type of,
you tell me under the law, can I go into all these documents?
I'll get the 202 document, 202 statement. So let's give me one.
Complaint is enough. See, the best thing is, you raise, I will give you the liberty to raise all this point, and I will also observe that whenever the application under 205 is moved, the same shall be considered.
No, that
and
a person to just to avoid the payment of the money, and when the suit has been declared
100% correct, but my problem is, can I go beyond the documents which are part of the complaint case?
I have given lordship can.
You have relied upon 100 documents.
How will I do go into? I have given some judgments, my lord. Those are clearly deals with these type of cases, my lord. Where the case of civil nature has been given a color criminal case just to avoid payment of money, my lord. I have given the Supreme Court judgment also. I have another
that I can do it only by going into your documents. Can I go through your documents at this stage? That's the trouble which.
Here, my lord, here is a case, a peculiar case. There is an agreement, my lord.
I understand.
There is an agreement, and you will also see the background. And these are improbable. You will also have to see whether this is a credible story. Statements first. To understand after now, I don't have, my lord. That is the first thing you should have. You brought all. You will also give me some time. I will get it, my lord. December.
Yes. No. This is a matter of 2016.
My lord.
Oh, no.
Now, in the next month,
I thought it's a fresh matter.
15 from 2016 onwards, what are you doing? This argument is clear. Before another day, the argument is clear that scientific judgment is to be dismissed. Without statement, how convenience can we take it? You can all backgrounds which is well noticed, admission that we what is those are the backgrounds no longer. Those are the background unless I see I'll get the program. I'll help you. I'll get the program. I'll try to give you this whatever possible. My lord. In the given circumstances, you get those documents, whether you file or don't file, give it to me. I just go through, right? So you take 15 time at least.
No, 2016 matter. Right, so it was smaller. Your fault only. I think it's fault.
No, for not listing the matter, it is not my.
No, today I'm talking about. Today you should have brought those documents. Next week. From 2016, I will see. These matters are, pending since 2016. Perhaps they are also not interested to prosecute you. That's the reason they are not coming.
The problem is that I have to come from Bombay.
You succeeded in your attempt by taking in interim order from 2016 and enjoying. They also thought that nothing is going to happen to get it. That is
interim order to continue.
Interim order to continue next week. It is made clear that no further adjournment shall be granted. Yes.
Item 90.
But why, Mr. Paul, why don't you do one thing? It looks like the complainants are not interested. And there must be some money decree or something might have happened there.
Yes, money decree has already happened.
So that they may settle it. So what I do is I will allow you 205 application you move that will be allowed. And raise all these points before.
I have to face the trial, man. If the complaint there is no filing of discharge there. That is the trouble. Otherwise, I don't have custody or lordship.
Yes. Okay, next week. Yes.
Item 90.
My pleasure, lordship.
90. Yes.
Dear my lord, Quashing of criminal proceeding, my lord.
Yes, sir.
The ground that victim and the petitioner number 3, since 2016, my lord, they have got married and they have children, my lord. Now they are staying peacefully. Compromise petition has been filed by Dynamic 16.
Only because the stay, my lord. This my lord, the asset could not be submitted, my lord.
Sometime time, on VC let them appear. I just want to authorize, they are staying together. Married also.
Staying together. The notices has been issued and
Forget about notice, they are staying together, what notice?
yes, sir. No, they have also
Your wife only
they have also appeared, my lord.
appeared?
Yes,
When?
cause list it is there, my lord.
No, all right, already appeared, council already appeared.
Council
But in fact, my lord, both of them will come here or other VC.
Let them appear to VC and class it finish.
Tomorrow, my lord, can take it over.
Tomorrow?
I will take instruction, my lord.
What instruction? 2016, what
It
instruction?
is from the
Friday.
Right. 16 investigation stayed. For that, asset man completed, but it could not be filed.
Investigation state, just imagine.
They were almost all some completed.
Investigation, how investigation could be state like this?
Further persistence, that is has not.
So Friday, it's made clear that no further action shall be.
If both parties come and file that.
The problem is if I dismiss it and they are happily staying today, again there will be a problem. So that you please get it so that I'll quash it. Okay.
91.
Yes.
Now from Mr. Sangram Das, what should you think? 91 and 93 together tomorrow balance.
No, that's not vigilance.
Is 91, no?
91 is not vigilance.
I'm sorry.
Yes.
Private.
Yes, my lord.
Yes.
Here, my lord, a defamation case was initiated against every
Defamation?
Yes, reputed newspaper, Indian Express, and all its editorials. Complainant is a ex. No, I'm
Still you continue to defame. 2015.
because
What defame?
and most interesting.
Is a newspaper.
Yes, my lord. Indian Express published 2 newspaper articles saying that the additional chief secretary of the state, the BDO is compounding
The gentleman officer.
Yes, he was then officer. In case of his house, the BDO is himself given a report it is non-compoundable deviation, but they are compounding. On the contrary, another person whose case is falling within the ambit of compounding are not compounding and demolishing. So that is why the news article read that BDO bleeds for Radhadat and short doors for other. Now, all these allegations made here are absolutely on record and to be correct. Not a single word is.
Nowadays, why don't you publish a small thing somewhere in a close place?
No, my lord. The question here is appropriate, my lord. I have my news article runs against the BDO, which is the statutory authority, and its manner of discriminatory approach as a statutory authority.
Show me the article whether his name is there or not.
My lord, his name is there. Then it's a fact. My lord, I have not stated anything which is not fact. I have not stated anything which is not. The record of the proceedings is also there, and he admits. So it is all being good. In exercise of 19G, when where is defamation? I have stated something.
Is a second 500.
Yes, my lord. My lord, maybe or any other things, then it is understandable. My lord, I have stated what is there on the record of the BDA, and I have annexed it.
Statement of fact. Statement of fact, no defamation.
No, it is not statement of fact. What is there, man? Because that means the complainant who was reading the task force to see the double alarm plan.
Right.
That is nearly subjected to some type of defamatory.
What is very defamation? Show me defamation.
Yes, ma'am.
Show me the defamation. Show me the article.
Yes, ma'am.
Article is at page 37.
Yes.
Maybe.
How you got defamation?
It leads for Taraja, the complainant. Soft goes to others.
Yes.
The Bhubaneswar Development Authority has mastered the art of bending its own regulations. There is one set of interpretation of the high and mighty, and another is it does not want to help. It can even manipulate the regulation in someone's favor. The case is point is
In point.
the case in point is additional to the complaint. Who was recently
Who has recently shunted out of the director of Gopal.
Is he really serious about it now? Well, he might have been retired now.
Yesterday, I had a telephone discussion because of this. He said, no, once my reputation has gone, everything is gone. So let me first try.
Why should
If you found not guilty, then no guilty. They haven't put a fight.
My lord, the question here is that whether why should I subject to a trial and when I'm a reputed newspaper and I publish something in third public good. I have not published anything which is
That is not the test. The test is if you say it is a statement of fact.
Yes.
Whether it is a statement of fact or not, that is to be established on record.
I have established that on record. The question here is on good faith. I am giving a binary that how they are dealing with the person. And these, my lordships, I have not, when the Taradot published that report of allotment of CDA land, at least 4 of the judges, sitting judges of our own High Court have been named in the newspaper. So they have not said run hurrying that their reputation is lost. So the same logic, my lord,
They wouldn't take it seriously.
the question here is my lord, I have not defended. What I have stated is a fact and made in good faith. It is my bad faith to defend me.
Again, that's the
That is what the Honorable Apex Court has said.
You are right. I am taking it on the statement itself. But whether it is good faith or fact, how will I ascertain it?
I have sworn, they have admitted every part of it. It's nothing that what I am publishing.
Where is that admission?
My lord, lordship page 40.
Yes.
Now, here the approval, say the video document, it says, last sentence, since the required left side setback deviation is more than 20%, existing structure is not compoundable.
Yes.
In this plot, then they have compounded it at page 42.
Yes.
So this is what I have published. My total approach is against the video. So I am not as a responsible newspaper, I am not saying the statutory authority doing this matter for high and mighty. What else I can do then? And so on record, I have not stated anything. And also you can see this is how the Honorable Apex Court has dealt in a very recent judgment. Okilo na likha hai se pano dukan karchu boli. Pan dukan business karchu.
It's a statement of fact.
Which is a statement, no, when it has made. So now the magistrate did not took any cognizance. Matter went in revisional court took cognizance. High Court affirmed the same. Both the court's order has been passed. So, paragraph 7. Having considered the entirety, the material available on record, we find that order dated 12/6/2017 passed by the London Magistrate First Class so rejecting the complaint of the respondent complainant is well reasoned order. The London Magistrate in its order referred to the fundamental right of the freedom of speech and held that publication in question did not warrant prosecution of the appellant accused for the offence punishable in section 500. Here also the news article published in good faith and exercise of fundamental right of freedom of speech and expression enshrined in 1901 and according to us, where I have committed any error or misrepresented everybody. Because the person is holding the guide and he commits another crime.
You would have said the video, no problem. You have taken the name.
Yes, I have to. Because, my lord, this is how the high-ranking persons in the society is to be judged. Now, they are imposing good law in the society. And they are becoming the violator of the law.
And what is my role as a newspaper is to why then the sensational headlines? No sensational headline. What is stated is absolutely with reference to the committee and everything. That is not sensation here. A person holding a very high post in the company can very easily push not the newspaper. And that's exactly what is the case video news. Yes. And I've shown the two documents. The building committee planning member says they are non-comfortable. And their rule says it is non-comfortable.
Yes. Yes.
And exception to your lordship can have.
Yes.
Exception to. This criminal case cannot be run against it. Public conduct of public servant. It is not defamation to express in good faith any opinion whatsoever respecting the conduct of public servant in discharge of his public function or respecting his character. Yes, so far as it appears to be conduct no more than. So my A and then my lord's also explanation. Sixth exception. Yes. Sixth, eighth. Eighth, my lord.
Yes.
It is not defamation to prefer in good faith an accusation against a person to any of those who have lawful authority over the persons with respect to the subject matter.
What explanation already?
Eighth, my lord.
Eighth, okay. Acquisition preferred in good faith.
And my lord, Senior is my lord, he has intended and he has also enforced that was his false activity in faith. He has enforced government land and filed an activity that was not enforced. Crossing the fund, I have managed the documents. Crossing the fund, the last document, the lawsuit can have. Page 56.
Yes. Yes.
No. 56, your lordship, this is Tahsildar report to be Tahsildar by planning member.
Yes.
Kindly see.
Yes.
The planning, since this private plot is difficult to assume with H, my lord. Where did you? My lord, with reference to, sir, I am reading the letter.
With reference to, yes.
With reference to the above, it is to state that an application has been received for approval of the building plan over plot number so-and-so Chandrasekhar. This plot belongs to him. It is ascertained that the owner of this plot is in possession of area 420.44 square meter as against the document area of 404.839 square meter. Since this is a private plot, it is difficult to ascertain whether the excess area lies within the width and length. The applicant, however, requested now to indicate the excess possession of which he will be able to vacate the same. So now they filed an application to they have filed an affidavit that I am not in enforcement of the government. So how, my lord, if it is law, they can do any false case being overstayed, and I cannot write that conduct.
The same plot, huh?
No, yes, my lord, for the same plot.
Yes. What do you say?
Can they have gone to my.
And what he says, my lord, before mine, what he says that I was not here, I have given, I engaged a contractor, the contractor has done some mistake, and he has ultimately demolished that person. So whether I am right or wrong, he has himself demolished it, and we have published it. We have published it. So look at
Yes.
My lord, all this, apart from all these things, what I have taken. Oh, then the complaint being agreed by.
Let me come to 34. Huh? Yes.
That the complainant being agreed by the defamatory publication wrote to the executive director of the New India Express on I-5 explaining the relevant fact, based on documentary evidence and seeking action. But no visible corrective action was taken, and instead the newspaper under reference published a total news item subsequently 21st
Demolition part of the.
Yes, you have demolished and you have in good faith shown it. That you do.
I was on deposition Delhi. I have given everything I have written.
Yeah, why have you demolished then?
Yes,
If it is not encroachment.
No, my lord, what happened, madam? That have.
That's your admission.
Yes, sir, I have given all this, that is my complaint person.
So that is what he says, that reading the complaint itself, it is the statement of fact.
No,
See, what was the problem? Why I was asking him question? He was relying upon many documents to establish that it is a statement of fact. He published in the newspaper. I was under doubt whether this document I can consider this stage or not. But from the reading of your own complaint, if you admitted the fact that there was a part of the portion which was enclosed, which after the publication, first publication, you have demolished it. It is a matter of fact. On admission on your part in the complaint itself. So therefore the good faith clause covers it.
Read that, my lord.
He is covered by the good faith clause under section 500 because of your statement in the
Page 27.
27. Okay. Yes. Yes.
While working on central deputation in the cabinet secretariat, Rashtrapati Bhavan 4 years ago, the complainant came to know that a part of the compound wall of his house had been fully damaged and a portion of the house enclosed in the process of construction of a multi-story building in the neighboring plot number 308 of 1801. The redress to inconvenience faced by the tenants, he came to Bhubaneswar and paid rupees 25,000 to the contractor who had earlier constructed his house in 2007-8 for reconstruction of the compound wall. Simultaneously, on being apprised of unauthorized construction and gross violation of BDS building regulation by the builder on the neighboring plot, the complainant submitted petitions to the relevant authorities, namely Vice Chairman BDS so-and-so, to the Director General Vigilance Bride so-and-so, and to the Commission of Secretary. The complainant also filed an FIR against the unauthorized construction and the resistant damage to his property by letter dated so-and-so. The complainant sent another communication to the Vice Chairman BDS by letter dated 28th of July 2011. Copies of all the documents could no doubt.
But the fact remains that there was unauthorized construction, which has been highlighted in the article.
That has been there in the newspaper. That means the unauthorized construction have been protected, made by Taraji protected, and others have been punished.
So why have you demolished your part? Tell me, answer it.
Yes, ma'am. I have narrated.
If it was not unauthorized construction on your part, where was the occasion for you to demolish?
Yes, madam. I am coming to that. I have narrated everything, madam. Then, madam,
can you demolish or not?
Yes, madam.
Yeah.
Because the compound wall. Compound wall.
But there was
Yes, madam. Yes, madam. Because there was that fact I stated. It is a matter of fact.
Why? You tell me why? Why have you done?
Because it is a matter of fact. I don't dispute that. But till then, what comes? Still then, upon coming to know that I have done all things, and then they published everything, and I wrote the letter explaining everything to them, and I said, please clarify this position in the newspaper. Instead, they published another article.
The prosecute video then.
They are the newspaper. They are the newspaper.
No. The fact that there was a encroachment on your part and the encroachment in the adjacent house, this is an established fact. I'm not reading any document. I'm reading your complaint. These are the facts germinating from your own complaint. If that is the case, the publication made by them is a statement of fact. So the good faith clause, they are covered by good faith.
My lord, this was done. This article was done when I became the in charge of the task.
Time is over.
I have given the report. And these articles.
Better you settle. Otherwise, I have to cause.
Let me talk to
Speak, see, here, I'll tell you, 2015 these articles were passed. And he very well get the defense of good faith and statement of fact. And second, you are already retired. It is already, everything is die down, die down. Why are you unnecessary getting into this thing? So why are you unnecessary? Another article will be published if I pass some order. Why are you getting into all these things? Again, you do him.
2 days after, because telephone.
Shall I send it to mediation? You do it and finish it up. Golden handshake. Golden handshake is better.
Mediation have no problem. Some person may not.
No, you one of you can participate.
Yes,
but you can participate.
Present.
See, resident editor is there.
Present resident editor.
Present resident editor, right. The petitioners are the how many petitioners?
News, New Indian Express.
The petitioners have. Inviting problem.
The culprit is Srimatha, not Srimatha locally. And he,
but he is still there. And he is also left. Okay, but he might have done, but he is not there with them now. He is not there.
Maybe those persons' names there, they are not there.
I know. The present resident commissioner will participate, and you also participate and finish it up. I don't. Petitioners have challenged the prosecution initiated by the opposite parties in ICC case number 2544 of 2015, whereby 15 under section 500 CRPC. On 7/1/2016, the learned SDJM had taken cognizance of offences under section 500 and 501/34 IPC against the petitioners. The petitioners have petitions are agreed by the said order and the prosecution. The present matter is pending since 2015. By
this challenge is pending since 2016.
16. 16. Or interim order, where is that interim?
Yes, madam.
Interim order from?
Stay for the proceeding.
Where is that order? 2016 order. Yes, 1 minute.
And that is lastly.
Interim order for the proceeding ICC case number. Right.
Pending since 2016.
2016. By order dated 29/11/2016. An interim order staying the further proceeding in ICC case number 2544 of 25 was passed by the coordinate bench of this court. Since then, the interim order is in operation. As a result of which, the proceeding, as a result of which, the case is lying in a dormant state. This is a case arising out of a defamation proceeding, and due to the pendency of the case since 2015, and in the meantime, the editor, then editor, and the reporter of the newspaper have already left the organization, and the opposite party has also retired from the service. Taking into consideration the aforementioned development, I am of the considered view that the parties should be relegated to the High Court Mediation Center for exploring the possibility of settlement. At this stage, Mr. Das and counsel for the petitioners submits that the present dispensation is being heard by Resident Commissioner. Who is the resident commissioner?
Present,
Resident editor.
editor.
You don't know the name. So means that in the mediation process, the present resident editor may be permitted to participate. Since the other alleged contemners, alleged accused persons have already left the organization. In view thereof, the resident editor of New Indian Express, Bhubaneswar edition.
Yes, ma'am.
Bhubaneswar edition is permitted to participate in the mediation process. The coordinator of mediation center is directed to fix a date and explore the possibility of mediation and submit a report. You can, if you are not staying here, you can appear through VC also. The counsel for the opposite party submits that after retirement, his client is settled well. Settled in his hometown at Pithoragarh, so he may be also permitted to appear in the VC through during the mediation proceeding. The same may be the mediator may allow the petitioner of opposite party number 2 to participate in the mediation process in video conferencing mode. Awaiting the report, leaves the matter on 25th
of November.
Little early?
ठीक है, lordship can fix that. 25th.
20th September? November?
25th November. 25th November.
25th November. Yes. Interim order to continue till then. Okay. Yes.
After discussion, can technology next week.
Yes.
Implement to contact.
Don't give a longer date. 2016 matter.
93.
Yes.
93, madam. May I pray this matter will be taken up next Monday, because here what happened, he has been granted. It may upon the status of the case, where at civil dispute between the parties, FIR is filed. Subsequently, after due investigation, the IO submitted that this is a mistake of fact. After 4 years, in some offense, a complaint case was filed where cognizance has been taken. So let me open the start, because in 2022, since the complaint has not appeared, notice was issued and he has appeared. Whether there is a chance of compromise, what is the status of the case? I'll open to Monday completely.
Learned counsel for the petitioner submits that since this matter is pending since 2016, into the model is operating. He wants to seek instruction from his clients regarding the present status of the case. Leaves the matter after 1 week. It's made clear that no further action is taken. Yes.
94. These are actual. Let's here the petitioners have challenged the order of cognizance in a case arising out of 498A, which originally started from a complaint case. The petitioners are 1 and 3 are married sister-in-law and 2 is the brother-in-law.
Yes.
And cognizance has been taken against petition number 1 and 2 under 490.
One is
the married sister-in-law as well as 3. Both are 1 and 3 are married sister-in-law. 2 is the brother-in-law, my lords.
Okay.
He is the husband of petition number 1. Now, my lords, before adverting to the facts of the case, the husband has already got a decree of divorce, my lords, under 13(1)(a) from the learned family judge Dhinkanal, my lords. That is what my instructions are. If your lordship will grant me that, I will file, wherein the learned court below has gone into the aspect of cruelty, and has allowed the petition for divorce, and that was challenged in the Honorable High Court, where both the appeals have been dismissed, my lords.
The 13 filed by you.
My lords, by the husband. I am the
On the ground of?
cruelty, my lords.
Okay.
And here
That judgment, if the findings recorded there, will have a direct bearing.
Yes, my lords. I'll just file. I have asked for the copies. My lords, if your lordship will grant me time, I'll file that decree of divorce. And but here the petitioners are in-laws, my lords. Sister-in-law and the both are married, as well as the petition number 2 is the brother-in-law.
Yes.
And sanction towards petition number 2 was never recorded when the cognizance was taken, because he is a gazetted government officer.
What sanction in the 498 case?
Lords, at least under the DP Act, my lords. It is a mandatory.
No, what mandatory? In the house you fight with your sister-in-law.
House. It was arising out of the complaint case.
That's very weak point. Don't insist on that. The fact remains that this is a case of 2016, and she got already, the wife and husband already separated, divorce and all. In appeal it is confirmed.
Appeals have been dismissed in the High Court. That is my
Nothing
instruction.
survives. How many accused persons are there here?
It's total 6. If your lordship will glance the complaint at annexure 1.
Yes.
But petitioners herein are the married sister-in-law and the brother-in-law.
Petitioner number 1 and 3 are the sister-in-laws, and whereas petitioner number 2 is the brother-in-law of the
husband of petitioner number 1.
Party number 2, opposite party number 2. The opposite party number 2 had filed a complaint being ICC case number 368 of 2015. The court below wide order dated
26/2016
had taken cognizance of the offence punishable under section 498 capital A /323 /342 /406 /34 IPC read with section 4 of DP Act. Mr. Pondal and counsel for the petitioner submits that in the meantime the complainant and her husband, the marriage between the complaint and the husband has already been dissolved. The
Lordship will record the decree of the case numbers as well, because I have soft copy.
The husband, this is the soft copy. The husband of the opposite party number 2 complainant, who is the co-accused along with the present petitioner, had filed a petition under section 13
one smaller 1B
number
CP number 47 of 2016, and the date of judgment is 16/3/2018.
Passed by
the learned judge family court Dhenkanal.
Family court has dissolved the marriage of the petitioner by
It has dissolved the marriage between the husband and the opposite party number 2. Here,
that's who is a co-accused with you.
He has not come up here.
Co-accused with you. Petitioner by accepting the ground of cruelty raised by the husband of opposite party number 2. Husband of the opposite party. Mr. Panda further submits that the appeal filed by the opposite party number 2 against the said decree of divorce has also failed.
Both have been dismissed for non-prosecution. That is what
they also failed. In the light of the aforementioned development, he submits that the present petition may be allowed. Next paragraph. Or the legal counsel for the petitioner Mr. Panda is directed to place on record the decree, judgment and decree passed by the civil court, family court so and so, leaves the matter on next week, 20 days.
No, so Lakshman gave me some reasonable 2 weeks at least. But I have contacted him today. It's 2016.
Soft copy you file it. I don't need certified copy. You are holding it.
No, I have it sent on WhatsApp. That's it.
It's all right. You file it. File it.
I'll take a print out and file it.
1 week. For the तक दे दो. Give it on 4th.
Minutes, maybe 5th.
5th, okay. 5th.
Interim orders is there, minutes.
Yes.
95.
Grateful minutes. Interim orders to continue.
Yes.
Message, my lord. In this matter, my lord, the opposite party, who is the father-in-law of the petitioner, my lord, he has passed away on last 18 September 24, man.
Oh. Father-in-law?
Yes, madam. Out of this pressure and this tension, and because of this domestic violence case, my lord, the person was so mal in type of situation, that's why he is heartfelt, my lord.
No. No, you have challenged what?
To cause that proceeding, my lord, DV proceeding.
DV proceeding. Then it will become infectious for him. Infectious. I don't. The petitioner challenged the order dated. Order dated. Petitioner seeking has filed the present petition seeking quashing of the DVB's case number 159 of 2023. I know, I understood it. I read it and I understood it. If informant died, it will not be infectious that way. And you say that father, I understood. Yes. Seeking quashing of DV case number 159 of 2023. 2023 initiated by opposite party number 2. Mr. Mishra, learned counsel for the petitioner submits that the petitioner has expired on 18 September 2024. You are saying out of the pressure, out of the
because the DV case, my lord. Yes, I was so harassed, my lord. And whereas surprisingly, the father of that lady, my lord, I was on the 12th day. He was saying this person is equal to God, my lord. This is the human character, my lord.
This I tell you, this DV proceeding and all these things are largely misused. Largely misused.
Totally misused.
In view of the aforementioned development, the present petition has become infectious, accordingly disposed of.
Interim orders transferred.
Dismissal is a
if there would have been conviction and all, you could have revived. Nothing is there. Yes.
96. May I keep it? Here is the petitioner page for 205 application in 139.
205?
Yes, my lord. Your lordship has directed other day opposite party number to appear and to pay 25,000. But the petitioner is not agree because he not issued the check and that account in the bank, he has not the account and he is working as a fitter.
Now, what was the order?
Order was if 25,000
opposite party number 2 submits that if the petitioner pays 50% of the check amount, he will not prosecute the petitioner. 50% also you don't want to pay.
No. ये कुछ मोर अकाउंट नहीं कि मो चेक इश्यू ही करेनी कि मो दस्खत नहीं हुआ. I want to fight the case.
Then you fight. I'll dismiss it. Yes, you will fight. Was the order dated 24/8/2023? No? What is that order? Convenience.
Yes, ma'am. No, 205.
Based on similar.
205. Petitioner is agreed by the order dated 24/8/2023, passed by the letter JMFC or the Attorney. What is this? Attorney. In ICJ case number, ICJ case number 50 of 50/68 of 2020/21, 2021, whereby his application under section 205 CRPC has been rejected.
Yes, sir.
Has been rejected. This court by the order dated by the order dated 18/3/2024 pass the following order. Okay. Subsequent thereto on the opposite party number 2 appeared through counsel. Next program. On 7/10/2024, this court passed the following order. Next program. Despite the aforementioned order, the petitioner is the Learned Counsel for the petitioner submits that the petitioner is not willing to comply willing to pay 50% of the check amount. 50% of the check amount. Taking into consideration the aforementioned statement of the petitioner, I am not inclined to entertain the petition. Accordingly, the same is dismissed. Yes. No problem.
98.
And this is relates to vigilance statement of
24.
Not
tomorrow. What is this case, by the way?
My discharge petition has been rejected. I took 2 grounds for discharge. Because the allegation that I forged the signature of the beneficiary and I misappropriated the money, that has been turned down by the expert. Because the basis is not sufficient to hold that I have
manipulated the signatures. Yes.
And the main victim, the beneficiary, he has died in the meantime. So on these 2 grounds, I sought for discharge. And
See, there is nothing then. See, how will you establish the case?
No.
And putting him to trial is a futile exercise, unnecessary.
And let it lie over, my lord. This is for the entire week. So the action can take up tomorrow. Yes. Tomorrow the trial court has fixed the date.
And it is no obligation.
Yes.
Yes. Then counsel for the Mr. Mishra, then counsel for the petitioner. On behalf of Mr. Das, then counsel for the vigilance, and adjournment is sought. Next paragraph. Mr. Mishra, then counsel for the petitioner submits that the matter is fixed before the trial court tomorrow. Tomorrow. He may move an application seeking an adjournment before the trial court. If such application is moved, the same shall be considered with the trial court. Leaves the matter. When?
It's next week.
Next week. Next week you come.
Next week
weekly. Next week the topic on this.
My lords may not take note of the fact that Mr. Das has sought an adjournment. It may be misunderstood.
If we will not, I will not write it. Why should I give that concession? I don't pass an interim order. You know that.
Yes, ma'am.
I will allow it straight away if he has a case. Once I give it interim order, I have to justify. Otherwise, everybody will say that how is it given. So that is the written. And I will put it little early.
Yes, ma'am.
1 day, let him take 1 day. Put it on 29th. 29th. It is made clear that no further adjournment shall be granted in this matter. 29 because I am passing that order, he has an objection. 29th will come up. These are the 2 points. He will establish that.
4th. Let it come on 29.
29th how?
Can be disposed of it. It can be.
Hey, I am convinced what you are saying. Subject to what you are saying is correct.
Yes, Mr. Das was asked to take instruction with regard to these 2.
But see, the main point is the beneficiary. on the strength of which you are
Investigation.
He has died.
Yes.
No, what on this? Yes.
Item 100, 99 is similar order.
Same order, 99.
Item 100, my lord, on behalf of Mr. Rautray, my lord, kindly if you for.
These are I think miscellaneous matters are.
Miscellaneous order.
9899 order may be uploaded in course of this.
If you allow me to go and.
Because the anxiety is there.
I'll do it, right? I'll do it.
Monday, my lord. Item 100.
Yeah, I think from tomorrow onwards we'll do. Let it be.
Yes, ma'am.
I'll give some dictation and all, I'll do that. Okay.
Hearing matter.
Tomorrow, only, all the matter tomorrow.
All matters will be aligned.
Maybe taken up tomorrow, only matters.
If I pass a negative order, now I'm not going to take it up tomorrow. I'll take it tomorrow.
Great comments.